Yes.
In item 7, I find an additional affidavit value yesterday.
What?
Item 7, I find an affidavit value. That will be,
Oh, this matter.
yes, my lord, that matter.
Similar matter was disposed of
Exactly.
yesterday, my lord, in WBC 4619/2023. I am appearing for cooperative society.
We'll take when the matter is called.
I bring it
Why? Why do you want it?
because my lord, notice when we filed the writ petition, notice not circulated. After filing of the writ petition, they just not circulated, just one notice has been hanged in a shop. We collect it, my lord. Thereafter,
Are you filing your nominations today or not?
we are going to file today.
You file it. I've asked them to file it, allow you. We'll pass the order after some time.
May I please your lordship? Lordship, I pray for listing of an item, lordship. For order.
Madam, you call Mr. Talukdar. You call Mr. Talukdar, okay, when the matter is taken up.
In this matter, my lord, MD Bora will be.
No. Ask Mr. Talukdar to come.
Okay.
Actually, in this case, Talukdar Allah filed writ petition. That is why he has some difficulty to appear. Some writ petition he filed in this regard. At that time, he was not a council, explaining council.
No, yesterday I have passed an
That's
order.
why similar order.
That order which has been passed out there yesterday, I've asked Mr. Talukdar to inform the authority to allow all these persons not on the ground of that 24/2021.
But they informed me that only those petitioners has been going to allow. We are not going to allow. them.
No, in fact, that is there, but I have asked them today, I'll pass that order. No, somebody has to inform. Ask Ms. MD Bora to be present.
Then
Yes, what is it?
May I please your lordship? Lordship, I pray for listing of an item, lordship. In this matter, lordship, notice was issued on 12/6/2023, lordship.
What is the matter about?
Lordship, the matter is relating to they are seeking a direction from the court, lordship, to investigate his complaint for appointing another chief vigilance officer, lordship.
So what
Lordship,
is the urgency?
Lordship, we have filed our affidavit in opposition, lordship. Lordship, notice was issued on 12/6. Lordship, matter may be come up for order on Tuesday, lordship.
No. You mention it before the regular bench. These type of matters mention you want to do it today, it's a different thing. Yes, item number 1.
Item number 1.
One bullish, no? Yes.
May I please, your lordship? Lordship, possible the matter for time being,
Why?
but serious. Still,
You can't argue without the other side being there.
no, he did not reach till here.
Huh?
He did not reach. He's on the way.
Who?
G Bordoloi.
Which G-board lawyer?
Respondent.
Who's there?
Oh.
What they are challenging? What are they challenging?
Also,
of
they
it?
have challenged the advertisement of 2010
Hmm.
on the ground that the registrar doesn't have the authority to issue that order, your lordship, that advertisement. For the post of 29, process server P on your lordship.
Impugn advertisement dated issued by the registrar of cooperative for filling out of 29 posts of process server without verification. Directing the. Now, what has happened to those people who have been appointed?
Lordship, I have been informed that they have been issued appointment letter in the year 2011,
Then
and they are serving in their respective post, your lordship. If your lordship kindly takes up the last order on which this writ petition has been dismissed for default, that is
this
on
one.
of this honorable court, your lordship, 31/1/2019. In that particular order, your lordship, if your lordship kindly takes paragraph number 4, your lordship.
Issued by the student. So various grounds have been raised. It has been noted that no order has been passed or explained of it. I filed a fingerprinting mentioning para 11 of the substances that certain witnesses to self on the mark.
Rashid, the paragraph number 4 is very specific, where it has been stated that on 2/2/2011,
Yes,
and on 14/2/2011, the appointment orders were issued in favor of those 29 selected candidates for 29 posts of process server peon.
then it was restored.
Lordship, it was restored.
Okay. After restoring, have you taken steps?
After restoring, this is the first date, your Lordship, after restoration of the petition.
Have you taken steps thereafter?
Lordship, I am not in this matter.
Oh.
Lordship, the conducting council is,
Non-appearance.
Lordship, he's on his way. He's coming.
Who?
Lordship, AD Chaudhary.
AD Chaudhary? You don't know?
No,
Just
Lordship.
become a judge.
No,
Then-
Lordship, advocate is also there.
Who is that?
Anandadev Chaudhary.
Okay. Where is he?
Lordship, he's in another court. He's coming.
Huh?
Lordship, he's on legs. He's coming.
Are you saying this is item number 1? He's not there?
Lordship, he just called me up anyway.
Why does he say that have they taken steps? It was off, reports off. Have they taken steps upon response number 6 to 35? Then we'll take it up after that. Item number 2. Number 2. Yes, what is this matter?
Lordship, this matter, I am challenging the improved proceeding of the respondent authority while accepting our voluntary resignation letter. My lord, that his lordship that on 1989, 16/3/1989, he was appointed as a constable in the border security force. Thereafter, he was serving the post. On 1999, when he was posted in the Dhubri, his wife suffered some medical negligence in the hand of the doctor of the respondent authority.
Hmm.
And accordingly, lordship, he preferred MA. Due to that negligence, his wife suffered some injuries.
Hmm.
And Annexa A lordship, page 16 of my petition,
What is that?
that lordship, that petitioner lordship that served a legal notice to the commandant, wherein claiming for the damages.
For what?
For that, his wife suffered some injuries in the hand of the doctors of the respondent authority. His wife was pregnant at that time. The doctor of the DSF authority has not taken proper care. As a result, some medical.
So on account of medical negligence,
Negligence.
so he issued a notice to his lawyer.
Legal notice, lordship.
Okay, then you are
And here-
Nirmal Sharma?
Nirmal Kumar Sharma, lordship.
Huh?
Nirmal Kumar Sharma.
You are the petitioner?
I am.
Nirmal Kumar Sharma. Okay, then
Thereafter, he was transferred to the another battalion.
because of issuing notice,
No, lordship, that some.
I have gone through the case on absence of without leave and so and so.
And
He was given an opportunity to show cause, register as so and so and certified that he is absent without leave with effect from here without any reason to cause. Stuff off from the strength of this unit. Okay, then
in the page 19 annexure B lordship. Thereafter, he was gone on the leave. He has not reported for the duty. Accordingly, lordship, the commandant issued an order for dismissal from the service. That is reflected the page 19 of my petition, annexure B. That order was issued on 19/10/2000,
okay, then
page 19. Being agreed by the order of the dismissal lordship, I preferred on the statutory appeal.
Hmm.
Statutory appeal is that we start from the page 20 annexure.
then
Lordship, thereafter that authority allowed my appeal. That order
page
is
28.
page 28, and accordingly, I have been directed to report before the commandant.
Period of absence from the date of dismissal to so and so will be regularized again. So you were reinstated.
I will reinstate. On that date, when I report for the commandant, I was imposed punishment lordship for 30 days rigorous imprisonment with
Notice
14.
steps to Senate after Justice Kutesh Singh, sorry. Yes, yes.
Yes. On 19. When I report to the Commandant Lordship, Commandant without following the due procedure. of
No, no,
law,
kindly see page 30.
Page 30 is my resignation letter. I am challenging this. Page 30 is a resignation letter, voluntary resignation letter. Page 31 is an impugn order. Resignation of the service entered by the Nirmal Kumar of the city hereby accepted without the pensionary benefit.
Now, how many, are you entitled to pension?
No, no, sir, I am not entitled for the pension because I am 14 years.
Why are
in
you
service.
aggrieved?
I am challenging the proceeding, accepting the resignation letter. Prior to accept the resignation letter, some procedure has to be followed. This procedure has not been followed by the Commandant Lordship. Being aggrieved, Lordship,
So what do you want?
I want to reinstate in the service.
Huh?
I want to reinstate in the service.
You by yourself have issued this communication. I therefore requested that, it is therefore requested that my resignation may be accepted immediately. I shall be thankful.
Yes.
Have you issued this communication at page 30?
Yes, Lordship.
Then why, if you have issued this, they have accepted it, what is your problem?
Lordship, my contention is that this resignation letter was obtained from me by putting a pressure.
Huh?
By putting a pressure by the Commandant. This is not a voluntary resignation letter. Due to the pressure meted upon me, I submit this resignation letter.
Okay, then thereafter what happened?
Then Lordship, that thereafter being agreed by the order Lordship,
You filed a suit.
I filed a suit.
Hmm.
It was initially in my favor before the junior division in the Punjab. Being agreed
At
by the-
Punjab?
Yes, Lordship, it is before the Punjab.
Hmm.
Thereafter, Lordship, the Union of India has preferred an appeal before the district court.
Hmm.
Before the district court, that suit was dismissed. Appeal was allowed in favor of the respondent.
Hmm.
I again approached the Punjab and the Haryana High Court
Hmm.
against the order, against the proceedings Lordship.
Hmm.
That is page 49. And this repetition was dismissed on 20 August 2010 due to lack of territorial jurisdictions.
Why?
It is that Lordship, that the proceeding was took place in Assam. And that is why they take the view that no cause of action arose within the jurisdiction of the Punjab and Haryana court. And therefore,
No, no, do you file this? What is this? What the proceedings did you file before the Supreme, before the?
before the Punjab and Haryana.
Hmm.
Lordship, I am challenging the impugn proceedings, Lordship.
So they filed an application. Oh, Mr. Counsel,
Lordship, the page
you filed a
suit,
suit.
yes.
They filed an application under Order 7, Rule 11.
Suit was
That application was rejected.
rejected.
And thereupon they filed an appeal against that. That appeal was allowed, thereby your application under Order 7, Rule 11 was filed by the government was allowed.
Allowed, Lordship.
And the suit, and there against you filed a revision application before the High Court. And the High Court says that nothing doing, you go there.
Do not territorial jurisdiction.
Then,
And accordingly, and immediately thereafter, I approached this honorable court on 2011.
Hmm?
On 2011, I approached this honorable high court challenging the impugn disciplinary proceedings. Disciplinary proceedings or accepting the process while accepting my the voluntary resignation letter.
so your case is that you are entitled to voluntary retirement.
Voluntary letter, they have accepted it. My contention is that my letter is not I have not submitted the application voluntarily. They put me some pressure due to the mental pressure from the commandant as well as some other issues.
Then why did you file a writ here? All along you have been filing a suit everywhere.
That cause of action took place in Guwahati, Lordship, in Assam. That battalion, Lordship, is in the Dhubri.
Then why did you file it out there, the Punjab?
Lordship, that
Because you are a resident of Punjab.
Punjab, Lordship, probably that,
So you filed it there.
yes.
And the suit was for decree of declaration that order of discharge is illegal, void, and so and so.
Lord,
And the court, the civil court passed an order
yes, yes,
saying that by virtue of the findings on the issues above, the suit of the plaintiff is decreed with cost and that the order dated 34 is declared null and void.
And
Defendants are directed to allow the plaintiff to get voluntary retirement and the defendants are further directed to release the retirement benefits.
yes, Lord,
Now, against that, an appeal was preferred.
by the Union of India.
Union of India.
Yes. And
Is the issue of notice? Oh,
that case,
section 80.
yes, Lord,
Section 80 is not complied with.
not complied.
So under such circumstances, the plaint was returned.
Reply was returned. And thereafter, I preferred the writ petition before the Punjab and Haryana High Court,
Challenging that.
challenging except
And as such, so all the other proceedings goes.
board, Lordship,
Now do you have this thing?
these things, Lordship.
Now, how can this court now decide
Yes.
that it was voluntarily or not? Tell me.
That rule 19 of an BSF rule says, prior to submit my voluntary letter, resignation letter, I have to obtain the permission from the commandant. Without taking the permission from the commandant, Lordship, no one can prefer them this, I want to go voluntary. Yes, rule 19 of an BSF rule says, Lordship.
Where is it?
Rule 19, Lordship.
Of,
Rule 19 of an BSF rules,
where do I get it?
1969.
Huh?
BSF Border Security Force rules, 1969. Rule 19.
CCS.
No, Lordship, BSF rules.
Why are these pension rules and whatnot?
Rule 19. Since Rule 19 has not been complied with. One issue. Second issue, Lordship, that
1968.
yes, Border Security Force rules 19.
No, that is an act.
Act is 1968.
So then resignation. Let us see the resignation, section 19.
Second, Rule
It
19.
is rule or section?
It is a rule, Lordship.
If it is rule, then why it is section, it has been mentioned?
Section 8 is relevant.
Huh?
Section 8 is also relevant. Section 8, Border Security Force Act, Section 8.
No member of the force shall be at liberty to resign his appointment during the term of his engagement and to withdraw himself from all or any of the duties of his
Except
appointment,
with the
except with the previous
permission
permission in writing of the
of the
prescribed authority.
prescribed authority.
Resignation. The central government may, having regard to special circumstances of any case, permit any officer of the force to resign from force before attainment of
Requirement,
the age of retirement or before putting in such number of years as may be necessary under the rules to be eligible for retirement. Provided that while granting such permission, the central government may require the officer to refund to the government such amount as to complete the cost of training, may accept the resignation under sub-rule 1 with effect from such date as may be expedient, may refuse to permit. So you say that without the central government's permission,
permission,
the question of resignation does not arise.
yes. Allow that one more.
What is there then?
One more aspect, Lordship, that commandant is my competent authority. Rule clause 4, sub-rule 4 of Rule 19 says. Prior to that, sub-rule 4.
Provision of rules shall apply to and in relation
of
to
the
the
subordinate
subordinate
officer
officer and enrolled person as they
as they
apply
apply
to and in relation to any officer of the force and the powers vested in the central government shall be exercised in the case of subordinate by a deputy inspector general and in case of enrolled by the commander.
So it's a commandant. Commandant is my authority. That is,
So he has to give you the permission.
yes, Lordship, that is one aspect. The second aspect is that, Lordship, that in the judgment of our High Court said, but it is in the case of the CRPF, prior to accept the voluntary resignation letter, some consultation is necessary, Lordship. That what is the consequences?
No, whether it is there in the rules.
That is
So
not in
then
the,
forget about that.
but in the office.
So your issue is only simple to that effect. That you see, the question of you submitting, you cannot by yourself
Yes, Lordship.
wish the question of voluntary retirement, you may be asked for voluntary and there has to be a permission be given and then only
Yes.
it happens. So
Because
when did you submit the voluntary retirement application?
voluntary resignation letter, I submitted on
8/4.
8/4.
And when was the order passed? 25/4.
Was 25/4.
Okay. Now we have to look into it. You may submit, but whether permission was granted or not.
Yes, Prior to that, I have to obtain the permission, then only I can file an application. Because I am the force personnel. I cannot leave the force without
So how do you obtain the permission?
to file an application, Lordship, that I am going.
Is this, on this application, page 30, be considered to be an application?
Yes, Lordship, but that is not an permissions.
No, no. This is, you are asking that, look here, I don't want to be there. I want to resign.
Okay.
And once you say that you have resigned, you want to resign, because it is therefore requested that my resignation may be accepted immediately. That is what you have stated.
Lordship.
So meaning thereby, wouldn't it be that you have also sought for that my kindly accept, this is the permission being sought for.
Lordship.
Now, whether there was a permission there or, you see, the only thing is, after this, whether there was a permission before 25/4,
Lordship.
that will be the
That is
aspect.
one issue, Lordship.
Yes, Mr.
My lord.
Was there any permission?
Yes, my lord, this is the, my lord, under the rules, my lord, it is governed by 26(4), my lord. The CCS rules, rule 26.
What is this border security rules?
My lord, rules, my lord, it is governed by the CCS rules, my lord,
That is CCS pension rules.
pension rules. Rule
That is only for
26.
pension, but does the can the CCS pension rules, which are only for pension, be applicable for the purpose of resignation?
My lord, it is.
Because the resignation has to be on the basis of either the FRSR or the specific rules.
My lord, in the earlier occasion, my lord, the question was put by an order, my lord. I have produced the instruction. Now, my lord,
I have some documents. Which one? Let me.
this is.
Are you saying about 1/4/2019? Yes, I have it. Don't worry. Hey, hello.
My lord,
What is
1/4/19.
Where you? Yes. Page 15. Yes, tell me.
My lord, this is the, my lord, the notification, my lord, which says that the resignation in BSF, my lord, would be governed by the provisions of Rule 26(4) of the.
Where? Why?
My lord,
You are reading which one?
paragraph 3, my lord.
However, the MHA has not accepted to the above proposal. Is it? You're reading what?
My lord, paragraph 3
Of
of the letter dated 1/4/2019.
1/4/2009. Okay, then
My lord, now the MHA has.
let us read paragraph 2 also.
My lord, it is to intimate that as per earlier instructions received from MHA, a direction was issued to all concerned via EBIT letter under reference to deal the case of withdrawal of resignation of BSF personnel under Rule 28A of BSF Rules 1969 instead of Rule 26(4) of the CCS Pension Rules 1972. Now MHA has conveyed a direction in consultation with DOPT to examine the request of BSF personnel for withdrawal of resignation in accordance with the provisions of Rule 26(4) of CCS Pension Rules 1972, till these rules are suitably amended or superseded by any other rules framed by DOPT or incorporating such provisions in Rule 19 of BSF Rules 1969. Keeping in view of the above, it is requested that the cases of withdrawal of resignation and reinstatement in service in respect of BSN personnel.
But Mr. Gupta,
My lord,
this is the document of 1/4/2019.
my lord,
That is why I asked you to read paragraph 2.
my
Read it again, paragraph 2.
It is to intimate that as per the earlier instructions received from the MHA, direction was issued to all concerned via EBIT letter under reference to deal the case of withdrawal of resignation of BSNL person under Rule 28A of the BSF rules.
So
Instead of
that was at that point of time.
that point of 2000.
This 19 only comes later on.
My lord,
We are concerned about the situation in 2003.
Three.
So how do you apply these documents?
my lord, it will be 28A, my lord.
Huh? So we have to go see 28A. Where do I get that?
57 of an PHF. Case number.
Now, did you apply for withdrawal of your resignation?
No. Nowhere, Malad, there is a Abatement, Malad, the resignation.
But
Did you ever apply or have you ever intimated
No.
anybody?
Never.
Then look here, this is what has happened.
That is-
These people have fraudulently or by force, they have done, and as such, I want to withdraw.
prior to filing of this case, no. No,
Then,
they have not approached the authority, but he has directly approached the court that the.
no, understood, but why not? You have not
Why not?
informed.
Lordship, because Lordship that he is not getting it after the dismissal, till the acceptance of the voluntary retirement, voluntary resignation letter. That.
That is only, that was done on 8/4 and 25/4. That is only 13 days or 15 days.
No, Lordship, initially dismissed.
So this is only a 15 days period, but why haven't you approached the authorities at that point of time and say that, dear, look here, this is I have not done it?
that may not be-
Because you could have filed an appeal. Or you could have at least say that that is not my document. Why haven't you done that? Till you approached this court in 2011 after 8 years. Because if you don't withdraw, or you may have to say that that was not been issued. You file a writ or a suit without notice under section 80. How can I give you any benefit of that? Tell me.
Paragraph 11, Malad, of our reply, Malad, we have stated.
Now let us look into this page 11 of your documents, which you have given on the last occasion. Filed by the respondent, item number 1, doc. This withdrawal of notice of voluntary retirement, 28 June 2002. Have you got that document? Yes. Page 11. Have you got it?
Malad.
This is the document at that relevant point of time.
Yes.
Seeking voluntary retirement from service is a major decision to be taken by the officer after considering the consequences and proper application. The authority competent to accept voluntary case of resignation is the Government of India, and therefore each application has to be forwarded to the Ministry of Home Affairs after obtaining the approval of the director for the acceptance. These voluntary cases are processed through the channel of MHA, and the approval of the government is being accorded by the JSP and above as per the rank of the officer. Of late, there has been a spate of withdrawal of voluntary retirement by officers even on the crucial date of retirement. Though as per rules, the option of withdrawal of voluntary retirement application is available to the employees before the crucial date of retirement. Such revocation is neither automatic nor can be claimed as a matter of right. In fact, the appointing authority can withhold the permission for withdrawal of the application. Frequent withdrawals of voluntary can have been construed by the competent to be indicative of favorable attitude of officers concerned and have desired that in future withdrawal of voluntary will be entertained only in cases where there is intervention of circumstances beyond the control of the that necessary such a request. In view of the when I am concerned, directed to request also and so to interview the officers concerned to ensure that a voluntary have been submitted after due application and also to caution the officers concerned that accepting exceptional circumstances, withdrawal of will not be allowed. It is also hereby that unless there is a specific recommendation by the IG for permitting withdrawal, such requirement would not be entertained. Resignation and in this regard, since no provision of the VHF regarding withdrawal of the notice, such cases were being dealt with by Rule 26 in this case. But if we go by Rule 19, I don't know whether it is a rule or what
It's
he.
a rule, Malad.
Huh?
It is a BSF, Border Security Forces rules, Malad.
Okay.
It is a rule, Malad, 1969.
Rule 19, if we go by that, first the central government's permission is required.
Malad.
Isn't it? So if there is no permission, now if we see 4, the provisions of this rule shall apply to and relation to subordinate officers and enrolled persons. Petitioner was what?
Yes, constable, Lordship. Constable?
What is that? Enrolled person.
Yes, Lordship, enroll person.
As they apply to and in relation to any officer of the force and the powers vested in the central government under sub-rule 1 and 2 shall be exercised in the case of by the deputy inspector and in the case of here. So
Enroll person.
instead of the central government, it will be
Commandant.
the commandant who shall give the permission. Now here what has happened on 8/4/2023, he submitted his resignation. There is no prior permission.
But
Now-
that is the letter, in fact, seeking
Understood,
permission.
whatever may be.
My lord.
Now, if we read this with this particular document, which we have taken it out, this one.
My lord.
So whether a consultation was not required, did you have a consultation prior to that? Because this is the relevant document at that point of time, 28th of June 2002. It's a AI issued by the Director General of Border Security Force.
My lord,
So
consultation.
there has to be two.
My lord.
There has to be a permission, which has to be followed by acceptance. Whether there was a permission.
Permission was there, my lord, in paragraph 11 of our affidavit in reply, my lord.
No, there must be document, na? Isn't it? You must be having the document out there.
My lord, that will be revealed from the records, my lord, because the official report.
What is that? It is herein stated that petitioner had himself of his full will tendered his resignation dated to answer, stating that due to his domicile he would not like to continue in sir and requested for acceptance of his resignation. Acting upon the so-and-so, Sri so-and-so, the respondent and the then commandant accepted his resignation from service with effect from 34 so-and-so. And the petitioner was struck off.
Thereafter, my lord, we have stated.
It is pertinent that there is a proper grievance redressal forum in the force to address any kind of grievance of the personnel. If the petitioner was forced to tender his resignation from the so-and-so, he could have forwarded his representation to the higher where when in a similar situation he did his appeal in the event. As such, the petitioner did not approach the grievance redressal. So that is okay. But whether a permission was granted, where have you mentioned that there was a permission granted in terms with Rule 19? You say at paragraph number 11 that you have accepted it. Fine.
My lord.
You have a power to accept it, which you can do it under Rule 19. (19)(2). The central government may accept a resignation under sub-rule 1 with effect from the date as it may consider expedient.
My lord.
Because here the exercise of jurisdiction will be done by the commandant. So 19(2) you will accept.
My lord.
But prior to that, isn't it the permission required for submitting the resignation? Because here also in Assam also, if we follow,
No.
you can't give a voluntary retirement out there. Look here, I want to go for VRS. No, nothing doing. You can't do that. You have to get your
Permission.
some permission. Now, if there was no permission mentioned anywhere, and the resignation having been accepted,
No.
wouldn't that be in violation of Rule 19? Yes, he has not approached. That is a later cause of action. But whether the resignation at all could have been accepted, That is the question.
My lord, the impugned communication, the impugned letter, my lord, accepting the resignation. Lord, that implies that the commandant has.
Oh,
taken
no,
possession.
no, no, no. No. There is a reason why.
My lord.
You see this. So that where finally come to section 8. No member of the force shall be at liberty to resign his appointment during the term of his engagement,
My lord.
or to withdraw himself from any of the duties of his appointment except without the previous permission in
Right.
writing of the prescribed authority.
That permission is the, my lord, the application, the request which
Without the previous, withdraw himself from all his duties or without the previous.
That-
He cannot resign
that is for a member of a force, my lord.
except with the previous permission in writing of the prescribed. Now, where is that? How do you take care of no person shall resign from his appointment during the term except with the previous permission in writing? Where is that?
My lord, this permission is writing is by the member of the force. This,
He's not a member.
And
he has, my lord, sought for permission.
No, no, no.
Or-
Is he a member?
yes, my lord.
Yes,
Definitely he's a member.
yes, my lord.
So how do you read? The section 8, read with rule 19, says that you need to have a permission in writing. And whether there is a permission in writing, there is nothing. You are absolutely silent on that.
Well, permission is writing by the incumbent, my lord, by the member of the force.
No,
It is.
except with the previous permission. Who will give the permission?
Come on.
It is the authority, the commandant is to give a permission.
Yes, my lord. My lord, the application for resignation submitted by the petitioner, my lord, that would be treated as a request seeking permission to
No
resign.
problem. There's
which
no
was
quarrel.
accepted,
Let us assume that
my lord.
that is a application seeking permission
My
also.
lord.
Then where is the permission in writing? Because here we are not, it's not a simple thing. The central government or the central forces have spent a huge amount in training him.
My lord.
And that is why one of the reasons out there that you should not allow him to resign out there in this manner, because of the fact that he has to otherwise pay that amount. Where is that? There is one clause out there.
29.
Huh?
My lord.
Rule 19.
Rule?
Rule-
Provided that while granting such permission, central government may require to refund the government such amount as would constitute the cost of his training.
My lord.
Then,
Apart from that, Lord,
Well,
from
the-
security
I have the-
judgment-
okay, now the
Original
issue has
record-
been solved. Issue solved. Now tell me what is the course of action next to do? We set aside that. Then what is the course of action?
My lord, the permission in writing is there, my lord. This is the record, my lord, which is the
If it is
service-
there, it is well and good.
Service record of the petitioner.
The matter is over, then permission is there. Because that is his only case. There is
This
no
is
other
the
case.
order, my lord. There is a-
Okay, that counseling is also.
No, that is not required. You have not approached anybody. Resignation from the
is the
service
service
rendered by
record.
so and so is hereby accepted with effect from Iman without mentioning benefit. He is struck off.
And this is followed by the order, my lord.
Sanction of the commandant is hereby conveyed for encashment of the. Where is it? Permission?
That is the permission.
No, no, no,
Order
that
in
is the order.
That is in the service book, my lord, of the.
Now, are you
petitioner.
saying
And
the
this is-
permission and the order would be one and the same? It will have serious consequences. If you want to say very well, I'll put it. Then every time there will be a mass resignation out there and they will say that, yes, I am resigning out there. Because it is the stand of the government.
Well, because this is.
Because
the-
that is not so.
That is in the service book, my lord. That is why I am submitting.
Understood?
this
But
is
where
the
is the
permission.
permission?
It is in the service book of the petitioner. And this copy is given to him also. So he is having a knowledge of the fact that the permission has been accorded, and that is followed by this impugned order, my lord, which is under challenge. There are two orders, my lord. One is a fact intimating that permission is granted to you, and then it is followed by the order And this order is also, my lord, it was from with effect from. So petitioner, my lord, ought to have withdrawn it before the date of its effect, my lord. It was made effective from 30 April 2003. And my lord, the first challenge was made by way of a legal notice after 1 year, my lord. My lord, the resignation letter was dated 8/4/2003. Resignation was accepted on 25/4/2003 with effect from 30/4/03. And the legal notice was sent. No, there was no documents, my lord, praying for withdrawal of resignation before the effective date. Rather, my lord, there was a legal notice sent after 1 year. That is in the year 2004. So, my lord, the fact that the resignation was
I
voluntarily.
accept everything. You see, only hurdle out there
No,
with you. He has not done many other things.
no.
He has not withdrawn. His voluntary retirement. He has not withdrawn, which he ought to have done. But the fact that the statute mandates a thing to be done in a particular manner with a written permission. Are you saying that you have given him the permission on 26/4? Because this document, which is mentioned out here, says that it is 26/4. Are you saying that he submitted his resignation on 8/4 and you gave the permission on 26/4 and dismissed on 34?
No, he was not dismissed. He was accepted. His resignation was accepted.
So his resignation was accepted on 34 without the permission is subsequent to his application for
Yes.
resignation.
His application was, my lord, made on 8/4/2003,
Understood?
which was considered by the authorities,
Very well. So you gave up permission.
my lord.
Have you intimated the permission to him?
So that is, my lord, there in the
No,
service.
there's
book.
nothing mentioned.
That order in the service book, it is within the knowledge of the petitioner.
You accepted it, thereupon you informed him.
Yes.
But did you inform that the permission was granted? Because your permission has to be in writing. This is not a permission. Resignations from so and so is hereby accepted. This
No.
document, kindly see, that can't be a permission.
My lord.
Where do you? Enough. Now what to do? So, Mr. Belbura, what are you asking for?
Lordship, that on 2011, when I approached this court, I was aged about 41 years. And now, Lordship, that I am after 13 years, it is 54 or 55. So death of superannuation is the 60 years. So I have remaining the 6 years service. So my humble prayer, His Lordship, I may be direction may be given to the respondent authority, taken back in my service, and all the national benefit.
No benefit out there. You have delayed out there. No benefit to all these things.
That only the very notional benefit, Lord.
You want to get the job, we can give you nothing more than.
Age is it? Age.
It's 41, I think 54, 55. And the age is around the.
No, but the reason why,
Lordship.
you see, why did not you withdraw?
Lordship.
Yes, termination was good, acceptance was illegal, but why did not you withdraw?
Yes, Lordship.
If that is the specific ground,
Yes,
your ground is that he has taken it by force. You knew it.
within the 90 days, he can withdraw it.
Within 90 days, why you did not withdraw?
Lordship,
And
that-
continue filing suit after suit and doing all these things.
Yes, Lordship, that is true. But one more aspect, Lordship, that respondent has, after dismissal from the service, I joined on the 2002. 2004, they have accepted my voluntary resignation letter. From 2002 to 2004, Lordship, they have not paid me a single penny. They have not afforded me the salary. When I approached the Honorable Court on 2011, then only they have
We have paid.
paid. After filing of the.
Now you have got that.
We have got.
I think now less than that.
These matters should have been dealt with then and there. Now, after 18 years,
Yes.
you have after 20 years,
2004, almost 20 years.
20, 20 years.
Because age of retirement is in 60 years. As on that, I am around 54 out of 55.
Yes, Mr. Gupta, what to do?
My lord, my humble submission, my lord, once the resignation is accepted,
No, you do one thing, best of. Mr. Basbura,
Lordship.
he will give you voluntary retirement along with pensionary benefits.
Yes.
I think that is the only way out.
But,
Because asking him to reinstate him at this stage,
Hmm.
and he accepted that civil judge's order.
Yes.
The civil judge's order was to give him voluntary retirement
no,
and the benefits. Because after 20 years, what will happen? And during this period, you must be earning also somewhere.
my lord, the point was he will not get pensionary benefits also. Because service is less than 10 years, my lord.
Lordship, voluntary retirement. we
No,
differ
no,
from the
for
total
that
lordship.
something has to be done.
Because, my lord, there is a
Services, if it is less than 10 years,
no, my lord, there is the,
Lordship, may I pray?
it was 2001.
Voluntary retirement with effect from the today. Then only lordship that I joined in the 1990.
Mr. Gupta,
My lord.
voluntary retirement will be from today,
Yes, lordship.
from the date, or from the date you have given. I'll give you 60 days for doing it. So this period will be then taken. That is the only way out. And then he will have this period of service.
Yes.
And taking into account that he has not shown any other document to show that he has been not earning gainfully anywhere, he would not be entitled to any other amounts. But this period shall be duly considered for the purpose of on duty only for pensionary purpose. If that is given out there, then he goes for a voluntary retirement, and then you give the voluntary retirement. This period only is taken for pensionary purpose, and you give him pension. That's all. Because 20 years after that, he has become a rust.
My lord.
You can't put him in a disciplinary organization. Ain't it? I think that is the only way out. Okay. Here. Where's he? This won't apply. The judgment of Justice Shah would not apply, because here is a case where resignation has been accepted. But here we are saying that resignation could not have been accepted without the previous permission.
My lord.
And the records also, there is no permission to that effect. So under such circumstances, we are setting aside that
My-
and taking into account for last 20 years, he has not been in service. This court directs the year from year until within 60 days, and within these 60 days, if you do it, this period shall be taken only for the purpose of pension. So Justice Shah's judgment would not apply. Justice Shah's judgment is 10 years and have not received 20 years, whether he will be entitled to.
My lord, this is one more judgment, but again, my lord, if
No, 10 years, there's no quarrel about the qualifying service. But here we are taking it to be the qualifying service in view of the resignation has been accepted to be wrong. That is the only way out, I see. Because today asking him to go back will be a huge, not only that, apart from that, there will be a lot of other things. Chalo. Okay, we'll dispose it off in this manner.
Yes, lordship. That voluntary retirement from we differ from today, lordship. Then
Not today. I'll give them within 60 days to decide,
then 16.
to give you the voluntary retirement. Because I can't give the voluntary retirement. The voluntary retirement has to be given by them. So they'll take a decision and they will give the voluntary retirement so and so. I'm giving them a liberty. Listen, I'm passing the order in your presence. The instant petition has been filed by the petitioner challenging the acceptance of his purported resignation by the order dated 34/2003, by the order dated 25/4/2003, with effect from 34/2003, and with a further direction that the petitioner be reinstated to his service and be granted his all consequential benefits. The facts of the instant case, as would be seen, the facts of the instant case is in a very narrow compass, taking into account the question of law involved herein. The petitioner herein joined the BSF, Border Security Force, for short the BSF, as a constable general duty on 16/3/1989. On 19/10/2000, an order was passed by the Commandant, 64th Battalion BSF, thereby dismissing the petitioner from service with effect from 19/10/2000. On the ground that the petitioner was absent without leave with effect from 11/6/2000 without reasonable cause. The petitioner thereupon preferred an appeal before the Deputy Inspector General The appeal was allowed thereby reinstating the petitioner and it was further observed by the appellate authority that necessary action can be taken against the petitioner under the BSF Act 1968 for his unauthorized absence from 11/6/2000 to 18/10/2000. And all concerned be informed after his absence has been regularized. Further to that, there was also a direction to take disciplinary action against the petitioner in the 64th Battalion. Next. It is the case of the petitioner that the Commandant 128th Battalion BSF had forced the petitioner to submit a resignation letter to him on 8/4/2003. And on the basis of which the petitioner submitted a resignation letter stating inter alia that on account of domestic problems, he wanted to resign from the job voluntarily. And a request was made that his resignation may be accepted immediately. Thereupon, on 25/4/2003, the resignation of the petitioner was accepted with effect from 30/4/2003, bracket dot A/N, without pensionary benefits. Thereupon, it reveals that after 1 year, the petitioner preferred a civil suit before the court of the Civil Judge Junior Division, Gurdaspur, in the state of Punjab, which was registered and numbered as civil case number 372, registered and numbered as RBT, civil case or
Civil
RBT?
case number,
Huh?
civil case number. I think.
Civil case number 372 of 6/4/2004. By a judgment and decree dated 18/9/2007, the suit was decreed, thereby holding that the order dated 30/4/2003, thereby declaring that the order dated 30/4/2003 to be null and void, and the respondents herein, who were the defendants in the said suit, were directed to allow the plaintiff, that is the petitioner herein, to get voluntary retirement, and were also directed to release the retirement benefits to the petitioner accordingly as per rules. The said judgment and decree dated 18/9/2007, passed in civil case number 372 of 2004, was put to challenge by the respondents herein before the court of the district judge Gurdaspur, which was registered and numbered as civil appeal number 21/2008. The learned district judge, by the judgment and order dated 3/8/2009, did not decide the appeal on merits, but held that there was no territorial jurisdiction of the trial court to entertain the dispute in view of the fact that the order impugn the order dated 34/2000, order dated 34/2003.
25/2000.
Yeah, it is written as 34 everywhere. The 34/2003 was passed at Guwahati, and the trial court did not have the territorial jurisdiction to entertain the dispute. Accordingly, the parties were directed to appear before the trial court on 10/8/2009 with a further direction that a plaintiff claim be returned to the petitioner under Rule 10 of Order 7 of the Code of Civil Procedure 1908. It further reveals that pursuant thereto, the petitioner preferred, what is that?
CWP, civil repetition.
Civil Writ Petition number 14888 of 2010 before the High Court of Punjab, before the Punjab and Haryana High Court, which was, however, dismissed. High Court challenging the order dated 34/2003. The said writ petition was, however, dismissed on the ground of territorial jurisdiction. Subsequent thereto, the petitioner approached this court by filing the instant writ petition on 21/11/2011. The record reveals that on 25/5/2011, this court issued rule It is further apparent from the records that there is an affidavit in opposition filed by the respondents. Wherein there was a denial that any force was employed upon the petitioner for submitting the resignation on 8/4/2003. In paragraph number 10, paragraph number 11 of the said affidavit in opposition, it was mentioned that the petitioner had himself, out of his free will, tendered his resignation dated 8/4/2003, stating therein that due to his own domestic problems, he would not be able to continue his service in the Border Security Force, and requested for acceptance of his resignation from the service as early as possible. It was further mentioned that acting upon the said resignation letter of the petitioner, the then commandant of 128 Battalion Border Security Force accepted his resignation from service with effect from 30/4/2003 by 128 Battalion Border Security Force Order number ESTT./857/128 BN BN/03/3269-82 dated 25/4/2003, and the petitioner was struck off from the strength from the unit with effect from 30/4/2003. It was further mentioned that the petitioner did not approach the appropriate authority for redressal of his grievances and had filed the instant writ petition, for which the instant writ petition ought to be dismissed. This court have duly heard the learned counsels for the parties and have perused the materials on record. from the facts narrated and the contentions of the parties, the issue which arises for consideration, there are two issues which arises for consideration. One, whether the acceptance of the resignation of the petitioner was in accordance with Section 8 of the Border Security Force Act 1968, read with Rule 19 of the Border Security Force Rules 1969. Number two, whether, if not, what relief the petitioner can be granted by this court. Next, for adjudicating the for the purpose of adjudicating the issue number one, this court finds it relevant to reproduce the provisions of Section 8 of the Border Security Act 1968, for short, the BSF Act, herein under. From a perusal of the above quoted provision, it would show that no member of a force shall be at liberty to resign his appointment during the term of his engagement, except with the previous permission in writing of the prescribed authority. Therefore, as per Section 8A, which is relevant for the purpose of the instant dispute, there has to be a permission. There has to be a previous permission in writing of the prescribed authority. Prior to submission of the resignation, prior to, and there has to be a previous permission in writing of the prescribed authority. Again, like that. Now coming to Rule 19, this court further finds it relevant to reproduce here Rule 19 of the Border Security Force Rules 1969, for short, the BSF rules. From a perusal of the above quoted rule, it would show that Subrule 1 of Rule 19 stipulates that the central government may, having regard to the special circumstances of any case, permit any officer of the force to resign from the force before the attainment of the age of retirement or before putting such number of years of service as may be necessary under the rules to be eligible for retirement. This court further finds it to take note of Subrule 4 of Rule 19, whereby the powers to be exercised by the central government in terms with Subrule 1 of Rule 19 had been delegated in respect of subordinate officer to the Director General, Deputy Inspector General, and in the case of enrolled person, by a commandant. Therefore, reading along Subrule 4 of Rule 19, with Subrule 1 of Rule 19, and the same being applied to Section 8 of the BSF Act, it would transpire that for the purpose of the petitioner to transpire, it would transpire upon application to the facts involved herein, that the commandant of the 128th Battalion would have the authority to exercise the powers under Section 8A, read with Rule 19(1). And the said commandant was required to give a previous permission in writing to permit the petitioner to resign his appointment during the term of his engagement. This court further finds it relevant to take note of the provisos, the two provisos to Subrule 1 of Rule 19, which further stipulates that while granting permission, that if an officer have rendered less than 3 months, 10 years of service, then the central government may require the officer to refund to the government such amount as would constitute the cost of training given to that officer, or 3 months' pay and allowances, whichever is higher. However, the same shall not apply in respect to those officers who had accepted a job under the central or the state government or local bodies after having granted cadre clearance for the same, or who have completed 10 years of service with the BSF. Subrule 2 of Rule 19 confers the authority upon the commandant in the instant case, the commandant 128th Battalion in the instant case, confers the discretion upon the commandant of the 128th Battalion to accept the resignation under Subrule 1 with effect from the date as it may consider expedient. Subrule 3 of Rule 19 stipulates when the central government may refuse to permit an officer to resign. Therefore, a combined reading of Section 8 of the BSF Act, read with Rule 19 of the BSF rules, show that without the previous permission in writing, an enrolled member like the petitioner cannot submit his resignation, or such resignation, if so submitted, cannot be accepted. Under such circumstances, this court put a query upon Mr. H. Gupta, the learned counsel appearing on behalf of the respondents, as to whether there is anything on records to show that any permission was granted prior to submission of the resignation, or there was any intimation so given to the petitioner that he could apply for resignation in view of the permission so granted. The records upon being produced do not show that there is any previous permission in writing prior to the submission of the resignation, or the aspect that the previous permission is required for accepting the resignation is also not taken into consideration. Therefore, taking into account the mandate of, therefore, as there is no previous permission in writing prior to the submission of the resignation letter, or prior to acceptance of the resignation letter, the acceptance, the order dated 25/4/2003, by which the petitioner's purported resignation dated 8/4/2003 was accepted, is contrary to the provisions of Section 8 of the BSF Act and Rule 19 of the BSF rules, for which the same is set aside and quashed. Now, the next question which arises, the next issue which arises is what relief the petitioner can be granted in the present facts and circumstances, taking into account that for the last 20 years, the petitioner is no longer in service. The effect of setting aside the order dated 25/4/2003, whereby the petitioner's resignation was effected from 30/4/2003, would mean that the petitioner resignation has not been effected. Resignation was not accepted. However, and as such, the petitioner would be deemed that the petition would be deemed to be in service during this period of time. It has not been accepted now. It's pending. Be deemed to be in service and would be deemed to be in during this period of time. This court cannot also be unmindful of the fact that for the last 20 years, the petitioner has not been in service. And to reinstate him to a disciplined service like the BSF would not be in the interest of justice. This court therefore permits the respondent authorities to take a call on the representation, to take a decision on the resignation, so given on 8/4/2003. As to whether the petitioner's service, petitioner's resignation can be accepted. No. Well, I would not do that. I would direct them to accept it as a voluntary retirement. But can this court direct that?
Well, we will take a decision following the rules and treat the resignation as a voluntary retirement.
No, that is you are saying.
No.
But shouldn't the court direct? Because tomorrow they may say something else. Would be deemed to be in service and because I can't direct to accept it. His resignation. Can I direct that?
If there was an error in following the procedure, we can do it, but my lord, since lot of period has expired, my lord, it may be treated as, the authorities will treat it as a voluntary resignation. However, no benefits should be given to, no financial.
No, that I'm saying that no pay, I will give it. There's no quarrel with that. But can this court direct voluntary resignation by him to accept? Isn't it your purpose to accept or not?
You know, since it is, the acceptance is bad in law, my lord has already held it. In view of that fact, my lord,
I can do one thing. I can record that the petitioner also does not feel that, and as such, from today it will be deemed that he has been the resignation has been accepted by you. But would that be proper?
My lord, almost in the similar circumstances,
Ah.
the coordinate bench has passed this direction lordship in the like this paragraph 18.
What does it say?
Paragraph 18 and the paragraph number 34. This is also the case of the CRPF lordship.
No, here it is a case of reinstatement,
Yes, Lordship.
but I'm not going to give you reinstatement.
My lord,
Yeah,
can-
20 years of service, you are not work out there, you are saying about reinstatement. Let me come back in 5 minutes and give a thought. This court cannot also be unmindful of the fact that the petitioner have not been in service for the last 20 years. And thereby to allow the relief of reinstatement to the service would not be in the interest of the service, interest of, would not be in the interest of justice. Therefore, this court heard the learned counsels for the parties in that regard. Mr. H. Bedburwar, the learned counsel appearing on behalf of the petitioner, submits that the period submits that he has no objection, that the petitioner has no objection if his voluntary retirement is accepted, is deemed to be accepted on the date of, as on today, thereby granting him the benefit of this period for the purpose of his pensionary benefits. Mr. H. Gupta, learned counsel appearing on behalf of the respondent, submits that it would result in affecting the discipline in the service if a person who was no longer who was not in service for 20 years is directed to be reinstated. Upon considering the submissions, this court is of the opinion that the interest of justice would be met if the petitioner is deemed to be in service till today. And his resignation is further deemed to have been accepted as on today. This court also agrees with the submission of Mr. H. Gupta that allowing the petitioner to be reinstated would affect the discipline in the service It is also the opinion of this court that as the petitioner have not rendered any service during this period, the question of the petitioner getting any service benefits such as salary, promotion, etc. during this period would not be in the interest of justice, in the exigency of the service. However, as the petitioner's resignation has been deemed to have been accepted as on today, the said period of service be counted towards the pensionary benefits while computing the pensionary benefits of the petitioner. Accordingly, this court therefore directs and observes and directs that the petitioner's service, that the resignation of the petitioner, the acceptance of the resignation of the petitioner on 25/4 by the order dated 25/4/2003 is set aside and quashed, and the petitioner would be deemed to be in service as on today, and the petitioner's resignation would also be deemed to be accepted today.
Clarify one thing, my lord, the rule 26 is not applicable, my lord, because if you go by the applicability, my lord, the notification which I have read, it says rule 26 would be applicable. Rule 26, my lord, entails forfeiture of past services. My lord will clarify that, my lord, it is of 2003. My lord, since the resignation was tendered in 2003, rule 19 would be applicable, because otherwise, my lord, rule 26 would come in.
I'm not saying about rule
No.
26.
No.
I'm only saying rule 19. I'm only giving here that these periods shall not be taken into for the purpose of any other benefit except for computation of the pension benefit.
But this would not be treated as a precedent, my lord, in special facts and circumstances of this case.
This court further directs that that during this period from 8/4/2003, or during the period from 30/4/2003 till date, the petitioner would not be entitled to any of the benefits such as salary, promotion, etc. But the said period till date shall be taken for consideration while computing the pensionary benefits of the petitioner. The above directions have been passed taking into account the exceptional circumstances of the instant case. The above the instant petition status.
No.
That is the only way out. Otherwise, reinstate it.
It is the voluntary retirement from today. This is not a resignation. Voluntary retirement from today.
Now, your resignation will be taken as has been accepted today. So, your resignation will be a voluntary, will be accepted from today, as on today. So, as on today, from 30/4/2003 till today, you will be getting the pensionary benefits, but not any other benefits. this period only shall be computed for the year, because this is only given so that tomorrow when you retire, you get the benefit out there for this purpose, only the pensionary. Huh?
Resignation. The use of the word resignation may entail a situation where it will be forfeiture of all past services, including for pension. If it is taken to be a voluntary resignation also. My lord, the Gujarat High Court had held that there is no concept of voluntary resignation. It could be an prayer for voluntary discharge. If it is a voluntary, if someone asks voluntary discharge, then it can be calculated for pension. Otherwise, in the case of a resignation, necessarily it has to be forfeiture of all past services, all benefits, including pension. Only prayer would be, my lord, if it is taken to be a case of voluntary discharge. I have asked for a discharge, let it be discharged. But if the word resignation persists, then it is forfeiture of all past service. That is the settled law, my lord. He would not be entitled to anything despite this order. They would be banking upon the word resignation.
No, rule
Voluntary. So what do you want?
That instead of a voluntary resignation, considering it to be a resignation to be accepted, my prayer for discharge from service can be accepted. If it is a case of discharge, then it
Shall
is
be
not-
treated as the
Then it can-
resignation which was there was not acted upon.
Then it is not a resignation, then it is a discharge I had sought for. That discharge is made effective from today. Therefore, all the past term when I was not there in service will not be counted for anything else except for continuity in service for pension, for pensionary purpose.
Mm.
So what I was earning on that day.
So
there
you
will
want
be
the voluntary discharge.
Discharge is the word, my lord.
My
Perhaps
lord, then on their submission, my lord, it can be recorded that they want the resignation to be treated
as
as
a discharge. Even if it is a discharge, my lord, then he will be entitled to something. The word resignation is the only bane in the entire petition, my lord. Had they discharged me at that point of time, or had they allowed me to retire at that point of time, yet under CCS rules, my lord, I would be entitled to 10 years of qualifying service. I get something. What the Supreme Court had held is, once I resign prior to 20 years of service, then I'm not entitled to any pension. That is settled law. The word use of the word
But your resignation was never accepted. That is what as of now, because I set aside that.
yes, so now at the end of the day, when Lordship has dictated the order, the end of the term, the end of the order says that my resignation will be. The word resignation is coming in the last 2-3 lines.
Shall be,
will
I
be
shall
considered to
put
be
it like
discharge
the resignation shall be, the application shall be treated as a application for discharge
Discharge. Then he gets the benefit.
as on date.
Nothing else.
I think we'll
Only
put
that,
it,
my lord, only that part.
okay, I'll make the correction.
So obliged, my lord.
Time being item 1.
এখন দি দিব লাগিব নেকি? Yes.
Lordship, this petition was earlier dismissed for default non-prosecution lordship. Subsequently, on 17th July 2023, it was restored. So lordship, before dismissal of the writ petition lordship, as per order dated 31 January 2019, we are supposed to take steps upon certain implemented respondents lordship. But since thereafter the case was dismissed for default, we did not take steps about it. So we have to take steps lordship. But in the meantime, while we have filed the restoration petition, certain respondents have appeared to counsel lordship. So I think I don't have to take steps upon those respondents who have appeared in the IA for restoration. Remaining respondents, I have to take steps lordship.
Now what do you want?
No.
You are challenging that that person did not have the authority.
Yes, lordship.
Let us see that.
Yes, lordship.
Now, you were petitioner, how many? One petitioner?
One petition. lordship.
Okay. Now, this advertisement, why are you challenging?
Because in this advertisement, they have advertised for.
Who are you?
I applied for this post, lordship.
Pursuant to the advertisement?
Yes, lordship.
Then,
Lordship, I have come to know that this advertisement was issued to fill up certain posts for which the appointing of authority is the district deputy registrar, Jorhat, lordship. But the Register of Cooperative Society Guwahati, he has advertised for those posts also, for which the appointing authority is the District Deputy Registrar of Jorhat Lordship. So Register of Cooperative Society could not actually advertise for those posts Lordship. But instead of that, he has advertised for that.
But did you submit to the advertisement?
I after submitting my application Lordship, I have come to know about that.
Did you come to know about at the time of result or before that? When did you file this writ petition?
Before declaration of result Lordship.
When was the results declared?
Lordship, the written test was held on 24/10/2010.
September
Hmm?
2020.
Written test was held on 24/10/2010.
Hmm.
And they have been called for the Viva on 1/2/2011 and 2/2/2011.
Hmm.
And we have already filed our affidavit, Your Lordship. We have stated.
And when was the results shown up?
Lordship, as per the affidavit, Your Lordship, on 14/2/2011, the appointment letters were given to the selected candidates.
14/2/2011.
Viva was conducted on 1 and 2 November.
14 to the appointment letter. So select list must be published earlier to that.
Lordship.
When was it? There are two advertisements, Mr.
Yes,
Counsel.
Lord.
Which one?
I am challenging the advertisement.
Dated
21st of July 2010. Your
21st of July 2010. Annexure 1 of the report.
21st of
July Lordship, 2010.
by the Register of Cooperative
Yes,
Society.
Lordship.
Okay. Now who should have published the result? Who should have advertised?
District Deputy Registrar Jorhat Lordship.
Why? If the Register of Cooperative Society is doing it, what is wrong with it?
Yes.
He is not the appointing authority,
So what? Isn't he the head of everybody?
Yes. but in other district Lordship,
No, forget about other registries. No, Cooperative Society. What is this?
they have filed the affidavit also Lordship. In that they have clearly stated that the Register of Cooperative Society is not the appointing authority.
Not necessary. Hey, Mutarasi. And on the same day, there is another advertisement, or this is done on 21/10.
Yes, Lordship.
One is 21/7 and one is 21/10.
Yes, Lordship.
Why are you enclosing 21/10? Yes, appointing, who does it? How is the appointment made?
Lordship, appointment. Otherwise, Your Lordship, Register is the head of all is the all in all, Your Lordship. Now, Your Lordship, for the process server peon, in our affidavit, we have stated that as there were as many as 66 numbers of posts for the process server peon, Your Lordship. And out of which 29 were for the head office and others on the respective at the district level, Your Lordship.
No, you see, the register is nothing but a delegate of the state government.
Yes, Your Lordship.
And the the state government does everything.
They used to maintain separate gradation list district wise Lordship.
It's okay, but that is a different thing. I would have understood that for Jorhat, Sibsagar district has done it, then you have a problem. But here is a case where the Register of Cooperative Society has done it. Who is the boss out there for the cooperative society? Mr. Talukdar,
Hello.
yesterday that order, I had to make a lot of changes. Although the order remains as it is,
Right.
but the order has, I had to say about this section 39 and all, where it is given out there, section 39. Because what was done out there on 24/2000, because the petitioner council did not apprise this court while dictating also. 24/2021 was the order by which these people, the zonal register said that, okay, whatever may be, you are dissolved for not holding the meeting of 2021.
2021.
2021 is the cooperative year.
Yes,
What will be the ending of the financial year?
my lord, cooperative year and financial year is, my lord, same. 31st, my lord,
31st of March 2021. It can't be before that.
yes, that is the.
If you see the financial year of 2020-2021,
Yes.
the financial year will be up till 31st of March 2021.
21,
And then 6 months,
30th of September.
30th of September. How could he pass the order on 24/2021?
For 2021.
And that too on the date on which it was the lockdown? The lockdown started from 19/4/2021 in the second phase. Then I think they must be sitting, no workouts. So at home they must be doing all this thing.
My lord,
Huh?
when he says, my lord, it is 2021, perhaps this AGM relates to, it cannot be of 19 also. It has
19 also the same applies.
to apply.
And 130A, because what has been mentioned was different. I'll pass the order. But however, my direction is,
Lord, yesterday, as per your lordship's direction,
I said that allow them not to insist upon the non-compliant, not to reject on the ground
Yes.
of
40.
44A and 44E.
Yes, subject to other disqualification.
That
Yes,
is other.
that is
I'm only
another.
on that.
Yes, correct.
And I said, because 28, they have not challenged the 28/2023 order,
No,
where the Register of Cooperative Society has said.
Yes.
I said that in view of the circumstances, the Register of Cooperative Society could not have said that 24/2021 was right. However, the direction that in the meantime, the period having been over, these people could not have hold the AGM. And as such, one man has rightly observed, will do it, but they cannot be made to disqualify for that.
Right.
And today there is one petition of Mr.
Item
Ahmed.
7, my lord, similar order, lordship.
The same order will
Yes.
be passed out there.
Yes.
So inform them.
Yes, in fact, in the terms
No,
of. the-
he's saying that only those petitioners
No, no,
will be
but in
allowed.
fact, as per your lordship's direction, I said that the members of the erstwhile boards,
Shall
they will
not
not
be
face
disqualified on 44A
Yes.
and 44E.
that much. Obligation.
Yes, tell me where is it? Under what provision these people are appointed? Who is the appointing authority for everybody? Hey, register of. Now, these people are appointed under what provision?
Yes, sir.
Who appoints these people, process servers?
Process server district, it should be deputy register of cooperative society.
How do you say so?
Lordship, they have.
And that service is where? There must be a service of these rules, services rules,
Lordship.
or do you follow the ministerial rules?
Ministerial rules, your lordship.
Show me the
Some-
ministerial
some
rules.
ministerial-
Secondio. Which one? Directorate establishment or the ministerial district establishment? 191.
191, your lordship.
191, does it apply? 91 they shall in these rules unless the context otherwise so. No.
No, Your Lordship, it ought to be Assam Directorate Establishment. Services,
This one,
1973.
where they have given it. Okay, yes. These rules shall also be applicable to the ministerial staff of the heads of the department mentioned in column 1 of the schedule 1, and government may time to time amend those rules. Now, schedule 1, column 1, director of register. You see,
Register-
head of the department is the register of
register-
cooperative
yes,
society.
yes, Your Lordship.
Why can't he appointing authority in respect of the register and the authority respective department, corporation department? And what is wrong?
In fact, Your Lordship, if Your
The
Lordship
head of the
kindly-
department who is issued this
Yes, and in fact, Your Lordship, if Your Lordship kindly takes up page 172,
page?
172. Here,
Yes,
7 register is there, Your Lordship. To the bottom, Your
appointment
Lordship.
shall be made by the
Appointing
appointing
authority
authority by promotion on the basis of seniority from among the registers or who have rendered service of. It has nothing to do. No. First and foremost, the register of cooperative society is the head of the department.
Yes, Your Lordship.
Huh.
And
Anything else? Nothing. The instant petition has been filed by the petitioner. Why do you spoil money? You're again taking steps. For setting aside and quashing the advertisement dated 21/7/2010 issued by the Register of Cooperative Societies, Khanapara, Guwahati, for filling up of 29 posts of process server without, on the ground that the same is without authority. The Learned Counsel for the petitioner submits that as the appointment to the process service, where in respect to the district of Jorhat, it is the district deputy register of cooperative society Jorhat who would have the authority to issue the advertisement and not the register of cooperative society. This court have duly taken note of the provisions of the Assam Directorate Establishment Ministerial Rules 1973, and more particularly to Rule 1(2), wherein it stipulates that the said rules shall be applicable to the ministerial staff of the office of the head of the departments mentioned in column 1 of Schedule 1. Full stop. In Schedule 1, in serial number 2 of Schedule 1, it has been shown that the Register of Cooperative Society is the head of the department. Is the head of the corporation department.
not cooperative society, Your Lordship. He's the head of the cooperative society,
The Register of Cooperative Society is the head of the corporation department.
Your Lordship.
So, taking into account the above, this court finds no infirmity in the issuance of the advertisement by the Register of Cooperative Society, advertisement dated 21/7/2010 by the Register of Cooperative Societies. Under such circumstances, this court finds no merit for which the instant petition stands dismissed.
Obliged.
Obliged, Lordship.
वो बहुत कागज की बात है जी বলবে তো এখন লিস্ট পয়সা নিয়ে গিয়ে আপা মেইন লিস্টখন নাই মেইন লিস্টখন বলছে
At about 3 to 5.
লিস্টখন yes Mr. Mahmood
My lord, in this
one phone
three cases, two writ petitions, one contempt, both the petitioners have died.
oh nothing remains
No, they have children. I have asked them to come, neither they are coming nor filing any petition. So the other day I have submitted.
what is the matter about tell me
Matter about the settlement of land which they were occupying during the pandemic, during the Zamindari period.
particularly the response number 2, 3, 4, and 5 to correct the revenue records of the land measuring so and so under the union as appearing. When did the petitioners die?
Exact date, my lord, this is one, Bireshwar Sil died on 18/1/22.
Huh?
Bireshwar Sil, he died on 18/1/22. And regarding Hemant Rai, I have no record. I have informed both the parties, but they are not coming.
No, we do one thing. No, we do one thing. We close the petitions as abated. However, liberty is given to the legal representatives to approach by filing a separate writ petition. That is the only way. You can't keep the matter pending if those people are not coming. That is the only way.
Or notice may go from registry, directly go to registry. From registry, notice may go to the,
That how can the notice go to a person who's the we don't have any information? Do you have the information who are the legal representatives? We don't have. So we close it, saying it to be abated. But thereupon, liberty I give it to the legal representatives to file separate writ petition if they so.
my submission may be recorded, they are not coming.
For what? That he is dead?
I have informed them, but they are not coming.
Ah. Mr. Contempt is a different matter. We'll take it differently. Huh? First of all, let us look into this.
That may be closed.
Huh?
That may be closed.
The contempt, okay. That closure is different. You can't close it on this because in contempt, the question of abatement does not arise. Okay. 4290 and 3455. The learned Mr. Ami Mahmood, the learned counsel for the petitioner submits upon instructions that both the petitioners had expired. He further submits that he has contacted the legal representatives, but they have not approached him back. This court further inquired with Mr. Mahmood as to the date on which the petitioners have expired. He submits that as regards the petitioner in WPC number
4290.
of 2021, 11, the
Yes.
petitioner expired on
18/1/2022.
18/1/2022. As regards the date of expiry of the petitioner in WPC number 3455/2012,
455.
2012, he has no knowledge the date. Be that as it may, the records further show that more than 3 months have passed by, wherein it has also been informed to this court that both the petitioners have expired. And none have approached this court seeking abatement, seeking to be substituted. Under such circumstances, both the petition cannot be proceeded with, as both the petitioners have already expired. Accordingly, both the petitions stands abated and closed. Liberty, however, is given to the legal representatives of the petitioners if they continue to be aggrieved on the basis of the cause of action as it's or for which the instant writ petition has been filed. Both. Now, contempt on sound here. What is this contempt business?
There is an order to act something, to record the name of the petitioner in contempt case number 220.
The whole
In that
exercise is
that was
directed
not
to be
done.
completed within 3 months. Till the process is completed, the possession of the petition. Are you in possession?
Now position is disputed.
Huh?
Now the government has taken the land for the purpose of construction of hospital, but no work is started. So now the lands are lying vacant.
In the writ petitions, my lord, affidavits has been filed, to which, my lord, perhaps they have not filed any reply. The pleaded stand in the affidavit is that, my lord, they are not in possession of the land in question. And it has been used, my lord, for some other purposes.
You have filed your reply. Have you mentioned now that the fact of that a possession of the land was handed by was way back in 19, which is the possession of the land until date, clearly negates the claim that he had been in possession. The instant contempt proceedings was initiated for non-compliance to an order dated
25/6/2010.
25/6/2010, passed in WPC number 1300/2009. The learned counsel appearing on behalf of the petitioner, Mr. Ami Mahmood, submits that the petitioner had already expired. Be that as it may, it being a contempt proceedings, and the contempt is between the court as well as the contemner, this court deems it proper to peruse the materials on the record under which the said contempt proceedings was initiated. It transpires from the records that this court, by an order dated 25/6/2010 in WPC number 1300/2009, dispose of the said writ petition, thereby directing the respondent number 3 to make an inquiry about the claim of the petitioner who was allegedly in possession of the land measuring 2 bighas, 1 katha, 5 lecha, situated at village Devhati under Sri Jangram Circle in the district of Bongaigaon for the last 60 years. It was further directed that the whole exercise be completed within a period of 3 months from the date of receipt of the certified copy of the order. Until the process is completed, the possession of the petitioner in the land in question shall not be disturbed.
It was communicated as for
It further reveals that there were certain communications so issued thereby requesting the respondent number 3 to the writ petition, that is the settlement officer Gwalpara and Bongaigaon, to make inquiry as regards the claim of the petitioner. There is also another communication dated 2nd of June 2011, wherein also it was alleged that the respondent authorities have not taken alleged that the Deputy Commissioner Bongaigaon had also not taken into taken steps in pursuance to the order passed by this court. And the revenue officials have, on the other hand, raised certain concrete pillars on the eastern part by encroaching the land of the petitioners. As the communication so issued, in spite of the order passed by this court, stood unredressed. The petitioner has approached this court by filing the contempt proceedings. It reveals from the record that respondent number 1, that is the additional Deputy Commissioner Bongaigaon, in charge revenue matters, have also filed a show cause by way of an affidavit. In the same land, in the same affidavit, it was mentioned that it is incorrect that the petitioners were in possession of the land 60 years back. In fact, the land is not in possession of the petitioner, rather it is in the possession of the community health center of Abhayapuri. It was further mentioned that the land measuring 32 bighas, 18 lechas, which includes the scheduled land covered by Dag number 360 old of Abhayapuri town, was allotted for construction of a 100-bedded hospital by resolution number 18 of North Salwara Subdivisional Land Advisory Committee held on 19/4/1984. And accordingly, advanced possession of the land measuring 32 bighas, 18 lechas, covered by Dag number 360 old of Abhayapuri town, was handed over for Abhayapuri Civil Hospital on 16/2/1985. And the matter was intimated to the SDOC, bracket C, North Salmara, by the Assistant Settlement Officer Sri Jangram, Abhayapuri, by letter dated 23/2/1985. It was therefore stated that the fact that the land was handed over for the construction of Abhayapuri Civil Hospital way back in 1985 clearly negates the case of the petitioner that he was in possession. It was further mentioned that on receipt of the letter received from the senior government advocate, Guwahati High Court, whereby there was a direction to the settlement officer to make an inquiry, an inquiry was conducted inquiry, comma. The settlement of the Deputy Commissioner Bongaigaon directed the additional Deputy Commissioner Bongaigaon, the deponent of the said affidavit, to conduct an inquiry through the circle officer Sri Jangram Circle in terms with the directions passed by this court within 3 months. And the inquiry report was forwarded to the senior government advocate, Guwahati High Court, on 27/4/2011. This court further takes note of that the other respondents have also filed their affidavits. Taking into account the stance so taken in the affidavits and that the inquiry was duly completed. Was duly made in pursuance to the order being passed by this court. This court is of the opinion that nothing survives in the instant contempt proceedings to be adjudicated upon in view of the compliance so made till date, so affected by the concerned respondents. Accordingly, the contempt stands closed.
And number 6,
Yes,
Lordship, petitioner before lordship is a master role worker,
what do you want?
but the regulation of his service method.
How?
But
How?
he was appointed on.
How can this court direct regularization? Tell me.
There was a direction from this Honorable High Court earlier, my lord.
Then
Is
that-
that page 11, my lord, the 10 and 11, my lord.
Now tell me which
And,
direction should I follow? That where's the direction by this court?
That is, my lord,
Huh?
at page 10, my lord, annexary.
8, 10. Yes, you are.
Lordship. At page 11, my lord, the party accordingly, this petition shall stand disposed of with the direction that the state law respondents shall consider the case of the petitioner for regulation in terms of the decision mentioned above, and also shall give some benefits to the petitioner as was given above mentioned decision. My lord, this decision was the, my lord, that is, my lord, the petitioner, the persons who were appointed prior to 31st, my lord, the March 1984, my lord.
Were you appointed in a sanctioned post?
My lord, the
Master role.
master role, my lord.
So master role not in sanction.
No, thank
So
you.
nothing doing.
Then, my lord, the process has been initiated to, my lord, regularize my post. After this direction, my lord, the process has been initiated to regularize my post.
Then
Then, my lord, unfortunately, my lord, I fell sick, my lord, and I was on leave for 5 months. And in that process, my lord, they have dropped my name from the, my lord, the list which they have sent for, my lord, regulation of my service. From that list, my name has been dropped. Then I have returned back and joined the service again. Then, my lord,
but the problem arises
I have-
that in the meantime, Uma Devi comes in. Uma Devi takes your right.
well, then, my lord, the
So tell me, how
direction
can this court direct after Uma Devi and the District Bar Association Bandipara that your services be regularized? Tell me.
Well, the
How can-
process which has been initiated, my lord, that.
Understood, but that is there. But
That
your
similar-
play now is similarly situated persons have already been regularized. So you
Already.
want a regularization.
And their
I can't
audit
give
process,
that.
my lord,
Impossible.
then, my lord, when I have joined, my lord, they have sent, my lord.
And another thing. What is your age?
He is right now, my lord, 59. 1 year left, my lord. Service, my lord.
Would you like to say to your client that you say fault of the court, the matter did not happen, and as such, now it has become infructuous after 1 year? So this court is not going to pass an order to that effect, but the issue is covered. The instant petition has been filed by the petitioner seeking a direction for regularization of the services of the petitioner. On the ground that the similarly situated persons have already been regularized by the government by the notification dated 30/9/2005 in terms of the scheme framed by the government. Where is the scheme?
Email to a lot of.
Hmm.
I have not asked, but it is my lot.
Who is paying for the government? Yes, tell me. 2005, you had a scheme.
No, my lord, scheme is not annexed in the affidavit, but stand is taken in para 7 of the repetition in pursuant to Umadevi's decision. my
Oh,
lord.
you have filed an affidavit.
Yes,
Wait.
my lord.
He was not working in the diary department since 2005. His name is not reflected in the list of 20. I was engaged as a master of 85 and was working till Iman. He remained absent from Moyan to Iman. And during the period, the master who joined the department were regularized by notification. The result of the absence of the You are not working since 2005.
No, I am still working.
Huh?
My lord, on 1/4/2005, my lord, I have left, my lord, I have taken leave, my lord, on 1/4, then I fell sick, my lord, I have returned back on 2010/2005.
Now, are you still in service?
Yes, ma'am.
That information I don't. That
Because
information.
here you are saying his service is discontinued since 1/5/2005.
My lord, lordship may come to pay annexure, my lord, the 3, my lord. Annexure 3 is my application after returning back, my lord.
Where is Annexure 3?
Annexure C, my lord.
C.
C, my lord. I have made an application to the director of.
No. As of now, whether you are
My
working.
lord, come to annexure D, my lord. This is the letter given by the director to the commissioner and secretary for regularization of my service.
Yes, madam. Here is not a case of not to. You had the scheme. You have not done it because during this period he was not there.
My lord.
Now, whether he's still working as a master role, just find out.
My lord.
We'll have it on today is 17th, 24th. List the matter again on 24th of August 2023. On which date Miss M. Burman
My lord.
shall apprise this court as to whether the petitioner still continues to render service after she is rejoined on
Wow, 2010, 2005.
2005. You get that instruction, we will. I think this is a case made out of the petitioner.
Item number 7, promotion.
Madam, they will be allowed. I passed an order,
My lord.
but let them participate.
My lord.
Only don't reject their nomination on the ground of 44A and 44E. All other grounds are open to you.
Lordship,
You'll get the order.
Lordship,
I'll dispose it of
my lord.
same like the other.
Yesterday Lordship was.
44A and 40. You inform.
My lord.
Because today I think
Last
2 p.m. na?
Act two, student will be on Act two.
2 p.m.
I will inform my.
You inform. Allow this petition.
Oblige, my lord.
Item number 24, promotion.
May it please advance. My lord, in this case, what had happened, a division bench of this honorable court, my lord, that is in PL 78 of 2012, passed an order on 9/12/2019, my lord. Lordship will get it at page 31.
Yes.
And the cooperative portion is at page 40, my lord. Para 9 towards the bottom.
Good.
We find that deputy commissioners of Bongaigaon, Kamrup, Metro, Morigaon, Sonitpur, and Tinsukia have been given responsibility to do the needful under the policy adopted by the state. In such circumstances, we hereby direct the deputy commissioners of the above mentioned district to take necessary action as required by law against the encroachers and file their personal affidavits, verifying the actions taken in this regard to remove illegal encroachment from tribal areas. In fact, division bench itself said, my lord, as required by law. Then, my lord, against this order, and SLP was filed, and that order, lordship will get at page 141.
Oh, this matter. That day where Mr. NNB Chaudhary is appearing.
No, that
Yes.
is different. And that is also a part of the thing, my lord. And
Where
that is,
some
yes,
your
that was
petition I have.
matter pertaining to Sonapur, my lord.
But your petition I take along with that. It came before this
Yes,
court.
yes,
Huh?
yes.
Yeah.
My lord, you kindly come to page 141. I'm reading from the first sub.
What happened in the Supreme Court?
Yes, that's what I'm, Supreme Court order, my lord.
Yes.
The principal grievance of the petitioners before this court is that peremptory directions have been issued by the High Court, which are likely to be construed as having been issued after recording finding of fact that the petitioners and similarly placed occupants in the concerned area are unauthorized occupants. This apprehension, in our opinion, is misplaced, for the tenor of the order which is impugned in this special leave petition is merely to direct the deputy commissioner to proceed against the unauthorized occupant in accordance with law, which presupposes that deputy commissioner must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of the evidence produced, before he proceed to pass appropriate order as per law. We may add that if that order is adverse to the occupants, the deputy commissioner must give reasonable time to the occupants to take necessary appropriate remedy as may be permissible in law. In other words, the deputy commissioner shall decide the proceedings uninfluenced by any observation made by the High Court in the impugned judgment and order. it will be open to the Deputy Commissioner to request the High Court to extend the timeline specified in terms of the impugned judgment and order, which request we are certain would be considered appropriately by the High Court. So what the Honorable Supreme Court said is, my lord, in an individual case, he give them notice, deal with their cases. Now, what the authority has done, if your lordship will kindly come to page 42.
Page?
42. My lord. This is the order under challenge.
Yeah.
Now kindly see the heading, public eviction notice. My lord, we are filing this petition in respect of serial number 1, 2, 3, 5, 6, 7, 9, 10, 11, 12, 13, 15, 16, 17, and 18. That means 13 petitioners are before lordship. Now, my lord, this is an order. There is no notice. That's why we are agreed. Our view, our submission is, my lord, as ordered by the Supreme Court, let them take action in accordance with law. So now this is a final order, as if, my lord, the determination has been done. Now a notice has been given to remove ourselves. That can't be.
Now, are you saying that the Supreme Court passed the order in respect to under what it is in
Against
this
the
order?
order of the division
This public
bench.
notice is in concern is in continuation to the
Yes.
order passed by the division bench.
Yes. Now, this is, my lord, this is an order, final order, as if a determination has taken place, where a notice was given, we replied, and then there was a determination that we are unauthorized. This is not the purport of the Supreme Court's order. Therefore, my humble submission is, my lord, this order is without jurisdiction.
Yes, Mr. Babuji, you have done this in pursuance to this Pudut Bora's order.
Yes, my lord, Pradut Bora is pending before the Honorable Division Bench. And from time to time, my lord, the Honorable Division Bench is issuing a writ of continuing mandamus. It is one such order which has been annexed to the writ petition.
Now, understood, but the thing is, have you done this? Have you taken these steps in pursuance to the Pudut Bora's order?
Lord, that I will have to obtain the instructions.
Okay. Now, you see this order being passed by the Supreme Court.
Yes, my lord. 141. the
It
time
is
is-
in respect to that order, PIL only.
Against the order of the PL, my lord.
Yes.
So this must have been brought now to the notice of the division bench.
Yes, Division
Because
Bench.
this order was passed in 2020.
Yes, now it is pending, my lord. It was last listed in the month of June. This PIL was last listed in the month of June. And they are, my lord, almost in respect of all the districts, the deputy commissioners have been filing affidavits from time to time, giving the updated status report, bearing, my lord, only few districts, 3 or 4 districts. To that extent, my lord, the Honorable Division Bench has granted 4 weeks time, my lord. But after,
No, whatever may be.
yes,
How do you take care of the observations made by the Supreme Court?
that's what, my lord, I will have to seek instructions. Because his pleaded case is, my lord, that individual notices has to be, a right of hearing has to be given. That is the sum and substance of the submissions.
So this exercise of power is done under what?
To that extent also, my lord, I will have to.
Under what provision? Under chapter 10?
Chapter 10, because chapter 10 does not, and he says, my lord, likewise, the provisions of rule 18 is somewhat different. But let me take the instructions, lordship will be pleased to issue notice here.
Okay.
To stay, I cannot consider, it is up to my lord. Because this,
Issue notice when?
lordship will kindly grant me 4 weeks time, my lord, because I will have to get the instructions from my lord BTC area.
Sidley.
In fact, that day I was thinking about that matter, na, that this post has appeared, na, a person who have been granted a settlement, not a settlement, he was allowed to run a particular shop, tea stall in a settlement of that.
That one, yes. my lord.
I was
Permi-
thinking about the
permissive
matter.
occupant.
I think the only recourse you could have been not under Rule 18, it has to be under the public premises.
Absolutely, because he appears to be a
Hmm.
permissive occupant.
Permissive.
That
So
was
couldn't have
that
been
was my-
under 18.
submission before this honorable court. He's a permissive occupier. So once I permit, I am now stopped.
Yeah.
Once I
Yeah.
permit, I am stopped.
Issue notice making it returnable on, you file your affidavit, huh?
My lord, my lord.
29/2023.
My lord.
Mr. Who appears for whom?
My lord, I appear
Mr.
for
Arbor Pujari appears for respondent number
my
1,
lord 1, 6, 7, and 8. My lord,
Six.
my lord.
6 also.
Yes, my lord.
Deputy Commissioner,
Deputy Commissioner here will appear, my lord,
6, 7, and 8.
because we are pursuing
Mr.
division bench, my lord.
Who appears for BTC? Mr. D.
Okay.
Chaudhary appears for respondent number 3,
4 and 5.
3, 4, and 5. And who appears for this backward area? I think Ardhar. Have you seen him somewhere? Yeah. He appears for this, no?
Plain tracks, yes.
Same time.
Respondent 2.
Respondent number. Ardhar appears on behalf of the respondent number. Respondent number 2. As the respondents are duly represented, extra copies of the petition be served upon them by 21st of August 2023.
My lord.
From a perusal of the writ petition, it transpires that the division bench of this court had by an order dated 9/12/2019 passed in PIL number 78/2012 had issued certain directions upon the Deputy Commissioner of Bongaigaon, Kamrup Metro, Morigaon, Konditpur, and Tinsukia to take necessary action as required by law against encroachers and to file their personal affidavits verifying the action taken in regard to removing illegal encroachments from the tribal areas. Further to that, the Principal Secretary of Boroland Territorial Council area, namely Kokrajhar, Chirang, Baksa, Udalguri, were also directed to file personal affidavit with regard to action taken for removal of illegal encroachments from the said area. Mr. K. Chaudhary, the learned senior counsel, has drawn the attention of this court that the said order passed by the division bench of this court was challenged before the Supreme Court in special leave to appeal bracket C D number 2121/2020, wherein the Supreme Court by an order dated 3/2/2020 observed the following. Observe. observe that the order which is impugned was merely to direct the deputy commissioner to proceed against the unauthorized occupants in accordance with law, which presupposes that the deputy commissioners must examine the claim of each occupant on a case-to-case basis, and after recording satisfaction in the light of evidence produced before him, proceed to pass appropriate orders as per law. The Supreme Court further observed that if that order passed is adverse to the occupants, the deputy commissioner must give reasonable time to the occupants to take recourse to appropriate remedy as may be permissible in law. The legal counsel, senior counsel, further drew the attention of this court to the public eviction notice dated 4/8/2023, which has been challenged before this court. A perusal of the said public eviction notice shows that the circle officer, Sidley, Revenue Circle, had informed the addressees to the said notice that as per the report of the concerned LM/SK, the said addressees were in occupation of government lands of area 45 bighas 0 kotha 0 lesa of village Hasraubari, which falls under protected tribal belt and block area. And accordingly, the petitioner, the addressees were directed to shift from the encroached bracket inverted comma protected tribal belt and block area within 15 days, or else action will be taken as per law. Mr. Chaudhary, why not this court direct to comply with this, what the Supreme Court did? Let them look into, submit their claims. You submit your claims, let them decide. This is what the Supreme Court says.
Yes,
I think that is a better option.
yes, till then, my lord, no coercive.
No, they will abide
yes.
by this.
In fact, our only procedural safeguard is, my lord, the due process of.
So this is what
Yes.
I think that is a better option. Then when they, because here they use the word as per law.
Yes.
So if it is said as per law, so obviously the law will be what the Supreme Court has said.
Yes.
No difficulty at all, but if my lord is disposing the matter, lordship will kindly fix a time limit within which my lord they will lay their respective claims before the deputy commissioner as per the number
No, no,
6.
it will be before the circle officer.
The circle officer is a subordinate authority. It will be before the deputy commissioner because the apex court order has my lord.
Okay, they let them submit these documents by 31st of August.
Okay.
I think 15 days is there. So they'll let them submit it by 15.
Any reasonable time limit?
And thereupon any decision is so taken, and the decision has to be intimated and give them so that recourse to them. So I quote this paragraph and dispose of that.
yes.
I think that
They
is the
will-
best.
They will file their respective individual claims before the deputy commissioner within a time limit. Then on receipt of the representations, deputy commissioner will dispose of those representations, giving each and every petitioner a right of hearing. That much.
That is the purport of the Honorable Supreme Court's
Yes,
order.
So I think keeping
Well,
this
our-
matter
but
pending,
Our expectation cannot be more than that.
more than that. So keeping this matter pending, you never know. So we'll do one thing, we'll do this, pass the remaining order
My lord, my lord.
The lordship will kindly direct the respondent
And
number
till then,
6
my lord, they will not take any.
at 2.
at 2.
At 2.
Yes, yes, no. Yes.
At page 101 of the book.
কিতাপখন দিয়ক
এখন কিতাপ আছে? এখন আছে নে?
আছে The instant writ petition has been filed challenging the notice dated 4/8/2023 issued by the Circle Officer, Sidley Revenue Circle. Whereby the petitioners along with the other notices, NOTICEE, were informed that they should shift from the encroached, inverted comma, protected tribal belt and block, inverted comma, area within 15 days, or else action will be taken as per law. Taking into account the issue involved, this court proposes to dispose of the instant writ petition at the motion stage itself. Mr. Chaudhary, please take a seat. The facts enumerated in the writ petition are that the petitioners have been residing in their lands since ages. And all of a sudden, the impugned notice was issued on 4/8/2023. Mr. K.N. Chaudhary, the learned senior counsel, has drawn the attention of this court to the order passed by the division bench dated 9/12/2019 in PIL 78/2012, whereby the division bench of this court issued various directions, including that the deputy commissioners of Bongaigaon, Kamrup Petro, Morigaon, Punitpur, and Tejpur have been entrusted with the responsibility under the policy adopted by the government state of Assam, and accordingly were directed to take necessary action as required by law against the encroachment and file their personal affidavits verifying the action taken in regard to removing illegal encroachment from tribal areas. In the similar vein, directions were also issued to the Principal Secretary of Bodoland Territorial Council area, namely Kokrajhar, Sirang, Baksa, and Udalguri, to file their personal affidavit with regard to the action taken for removal of illegal encroachment from the said areas. The learned senior counsel further submitted that it is on account of the directions so passed by the division bench of this court that the impugned notice have been issued. The learned counsel further submitted that the respondent authorities have not taken into consideration the order passed by the Supreme Court dated 3/2/2020, which is an order passed on a special petition being SLP, a special leave to appeal bracket C D number 2121/2020 against the said order dated 9/12/2019 passed in PIL number 78/2012. The learned senior counsel further drawing the attention of the court submitted that it has been observed by the Supreme Court that the deputy commissioners must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of the evidence produced before him, is required to pass appropriate orders as per law. The learned counsel further submitted that even any adversarial orders are passed, the same is also required to be informed by the deputy commissioner. By giving a reasonable opportunity to the occupants to take recourse to the appropriate remedy as is permissible in law. The learned counsel therefore submits that the issuance of the impugn notice has created an apprehension in the mind of the petitioners that they would be evicted from their respective possession of their lands without adherence to the observations of the Supreme Court in the order dated 3/2/2020. Mr. Arbor Pujari, the learned counsel appearing on behalf of the respondent numbers 1, 6, 7, and 8 submits that a perusal of the impugn notice dated 4/8/2023 shows that the circle officer, Sidley Revenue Circle, had directed the petitioners to vacate the land, or else action would be taken as per law, meaning thereby that the order passed by the Supreme Court dated 3/2/2020 would be adhered to. Order, the observations passed by the Supreme Court dated 3/2/2020 shall be adhered to. Mr. B. Chaudhary, appearing on behalf of the respondent number 3, 4, and 5, had also submitted in the similar vein as was submitted by Mr. Arbor Pujari, the learned counsel for the Revenue Department. Arbor is not there. Upon hearing the learned counsel, this court have duly perused the materials on record, as well as the order passed by the Supreme Court dated 3/2/2020. Taking into account the relevance the relevant portion of the said order passed by the Supreme Court is reproduced hereunder. 141 of the this apprehension of in our opinion is misplaced of i.e. a uninfluenced by the observations by the High Court in the impugned judgment. From the above quoted provision observations of the Supreme Court, it transpires that the directions so passed by the division bench of this court dated 9/12/2019, thereby directing the deputy commissioners to proceed against the unauthorized occupants in accordance with law, have been understood to mean that the deputy commissioner must examine the claim of each occupant on case-to-case basis, and after recording satisfaction in the light of the evidence produced before him, should proceed to pass orders as per law. It was further observed by the Supreme Court that if the order is adverse to the occupants, the deputy commissioner must give reasonable time to the occupants to take recourse to the appropriate remedy as may be permissible in law. And the deputy commissioners were also directed not to decide the proceedings uninfluenced by the observations so made by the division bench of this court in the order dated 9/12/2019. This court had put a specific query upon the learned counsels appearing on behalf of the BTC, as well as the upon Mr. Specific query upon Mr. R. Borpuzari, as well as Mr. B. Chaudhary, the learned counsels appearing on behalf of the respondents. This court also finds it relevant at this stage to observe the submission of Mr. R. Borpuzari to the effect that, taking into account the observations so made by the Supreme Court, the petitioners may be directed by this court, if so advised, to submit their documents regarding their claim by 31st of August 2023 before the Deputy Commissioner, Sirang, that is the respondent number 6, and the Deputy Commissioner Sirang shall adjudicate the said their claims on case-to-case basis and thereupon pass appropriate orders in that regard. Taking into account the above, this court disposes of this court therefore disposes of the instant writ petition, thereby granting liberty to the petitioners herein as well as the other notices to the notices of the impugned order dated 4/8/2023 to submit the relevant documents on which they rest, to submit the relevant documents pertaining to their claim over the land in their possession before the Deputy Commissioner Sirang, that is the respondent number 6, by 4 p.m. of 31/8/2023. The Deputy Commissioner Sirang thereupon shall adjudicate the claims, shall examine the claims of each of the persons, of each of the petitioners, as well as the other notices who has submitted their claims, and only upon recording satisfaction that the petitioners have no right to remain in petitioners or the notices have no right to remain in possession of the lands in question shall pass appropriate orders thereupon. This court further finds it also relevant to observe and direct that the respondent number 6 shall also upon passing of the orders duly communicate the same to the petitioners. How? No. They will do that. They know, but how? Whether they don't receive then? Shall to the petitioners as well as the notices of the impugned notice dated 4/8/2023 and further grant them reasonable time of appeal against this. Appeal is permissible.
No, I think they
Read.
appeal, I say Board of Revenue taken like.
To approach the appropriate forum.
Yes. A reasonable time matter.
30 days. 30 days, I think one has to be,
Yes,
because the
good enough,
reasonableness,
good
30 days. And thereby grant further 30 days time to the occupants, to the petitioners as well as the notices of the so-and-so, of the impugned notice. If any adversarial orders are passed, to take recourse to the remedies as available in the law.
Yes.
I have said about the notices. All the notices will be there only. I'm not saying anybody else. The petitioners as well as the notices. The petitioners, all petitioners are here. The notices
Only
are,
13
but there are
petitioners.
some others. Why? Okay. Itu line lekho. Taking into account, now, Mr. Kane Chaudhary, the learned senior counsel, further submitted that 15 days time so allotted would expire by 19th. And as such, this court may direct the deputy, may make necessary observations in that regard. Taking into account the above, this court, therefore, directs Mr. R. Borpuzari, the learned counsel appearing on behalf of the respondent number 1, 6, 7, and 8, to apprise these authorities that this court has today passed an order giving the liberty to the notices of the impugned notice to file their respective claims by 31st of August 2023 by 4 p.m. as well as the direction so passed.
Deep level.
Why do you need? You want a certified copy? Enough. Why do you need that small? There are other people who are not there. Be reasonable. One thing good about that order is there's something handle now is being given to this Rule 18. Now, this I will help you. Mr. Chaudhary, kindly do something as regards Rule 18. You see what has happened? I've been telling everybody. Rule 18 earlier to 1997
7 amendment.
only had 3 categories of land. Then comes Radha Kanun saying, okay, then they amend Rule 18. And once Rule 18 has been amended, even your land, you want to throw Mr. Chaudhary, who is there in occupation of his land, you can approach him and throw him out.
Get a notice issue.
It's a very serious, or it's an executive power which is very
By which the deputy commissioner will decide the representation. After a time limit of 2 months will come. Because it is kept, my lord, pending, my lord.
whose loss? It is not his loss.
Hmm.
And if you can't control your people, why should I fix? Now tell me, give me a good reason. Why should this court fix? Are you saying that you have some serious doubts about your own deputy commissioner? Then I have not said anything. Why is it necessary? I have given, you may dispose of next day also.
In 7 days also, 10 days also.
That is your lookout.
Deep problem.
Okay.
Production list item number 1 for withdrawal.
Mr. Chaudhary, this direction of giving certified copy along with the
Yes. We'll do that.
the petitioners as well as the notices. No, why I didn't want to put it, because the notices are not here. That is why I didn't want to. So any of the petitioners to the writ petition is given the liberty to is directed to serve any of the petitioners to the instant writ petition is shall submit a copy of the certified copy of this order to the Deputy Commissioner Sirang for due compliance.
Deep problem.
My lord, order, be the basis of their laying the, therefore, my respect to the.
No, but what happens tomorrow? Your people will reject as those are not there in the petition. How can the non-petitioner will get a certified copy? So one order is there. If you have 10 posts of deputy commissioner, it's a different thing. Yes.
Withdraw, my lord, with liberty to file.
You want to withdraw?
Yes, ma'am.
What is this liberty business?
My lord, this writ petition was filed, in fact, because my bank account was freezed by the deputy commissioner. Now some arrangement is chalked out, my lord. Probably if I withdraw, they will. If I withdraw, probably some arrangement has that if I withdraw, probably the bank account would be defreezed, my lord. So in case in future, if they do not do so, liberty only to put that extent. Withdraw it.
No. Has it been defreezed?
No, it is yet to be defreezed, my lord.
But you say there is something out there that they will defreeze
That probably they will defreeze, my lord.
if you withdraw.
If I withdraw.
Then wouldn't that be obstructing the course of justice by the deputy commissioner?
My lord, that will be better.
If he's saying when an adjudication is not being allowed, subject to, or he would defreeze if they saw. If it is a different case that he is going to do, it's a different thing. Yes.
My lord,
Who is appearing for the deputy commissioner?
But I'll be withdrawing this, my lord.
You want to withdraw? No liberty. It's very fantastic.
My lord, liberty only because if this man tomorrow suffers, only to that extent I was praying. I don't know to make an.
Mr. M. Biswas, the learned counsel. Oh, you are here?
Yes.
You are supposed to appear through this.
Yes, at 2 o'clock.
Okay. You are going somewhere now.
No, I'm not going at 2 o'clock. Your lordship has picked.
But you were supposed to do by video conferencing.
No.
Okay. That matter. The 10 rupees
Handcuffing.
handcuffing.
Yes.
Yes. Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. He, however, submits that liberty may be given to him for filing afresh if the freezing of the bank account of the petitioner continues. So, taking into account the above submission, the instant writ petition stands closed on withdrawal. As regards the liberty so sought for, taking into account that the uh, uh, the liberty sought for is not necessary, taking into account that the continuing of the freezing of a bank account gives a continuing cause of action.
I'm deeply aware.
Production list item number 2 for motion.
Lord, with a limited play, I am before your lordship. Lordship, the petitioner is a normal plot of land. Now, adjacent to that, my lord, PW has constructed a road. Now, in upper stream, my lord, some of the occupiers are there who are actually patta holder. Now, they are constructing the road at their own instance, and now they are destroying by the ground level height, my lord. Lordship, page 20 and 23
What?
photographs.
The limited prayer is such
My lord,
that your submission I couldn't understand.
Yes,
only.
lordship, because my lord, only thing is that let them take action, my lord, properly and field verification. And so far, respondent 4 and 5 are concerned, lordship. A action again to maintain the status quo as on today till next date, my lord.
What is it? I don't understand. What has happened? Tell me.
My lord, the petition.
You have submitted some representation
My lord,
regarding what?
my lord, thing is that
Illegal construction of public road carried out by respondent number
4
4.
and 5, my lord. They are the, my lord,
4
some
and
of the
5.
persons.
How are 4 and 5 making any public road?
Exactly, my lord. Thing is that because they are building, their house are situated on upper stream, my lord. Now, because that height, in order to maintain the height, they are now making the construction at their own instances, my lord, by filling up the sand and stone, etc. Because, my lord, that other side.
So you have a dispute between you and respondent number 4 and
No,
5.
I do not have a dispute.
Why you don't take
No,
an
my lord, I don't
injunction?
have a dispute, my lord. My dispute is only thing that they are now destroying the existing public road which has been constructed by the PWD. And they are also now filled up the drain which is now maintained by the, my lord, government authority. The thing is that
And you have submitted a representation which had not been.
we have submitted repented all concerns. They are not taking any action. Therefore, lordship, what I am saying, my lord, at this moment, let them make a field inspection and submit a report before your lordship. And so far, the 4 and 5, because they are carrying out the construction, the status to agent to be maintained, my lord. I think that will not, my lord, hamper anything. Anyone.
Absolutely, it will hamper.
My thing is that they cannot take the law in their own hand, my lord. If suppose somebody will construct the road at their own suitability, my lord.
Can somebody enter into your land?
No, they are not entering.
No, I am asking you.
My lord.
Can somebody enter into your land?
Absolutely not, my lord.
And if he enters, what do you do?
My lord,
No,
civil
what
code
do you
is a
do?
separate- my civil code is separate part because, my lord, kindly see, there all action to be contemplated by the government agency, my lord. They are sitting silent. That's why, my lord, we invoke 226, my lord.
Yes. If it is a PWD road, how is somebody constructing on that? Can they construct?
Lordship, they cannot, for the PWD road is constructed to this house. House next to his neighbor. And thereafter, someone has purchased the land of him, and they are making.
So your PWD, that's not PWD road.
Lordship, that we do not have any knowledge. Now let's see if it is, it can be extended or repaired or whatever.
But as of now,
Lordship,
we'll take it up on Monday. You get your instructions as to whether the PWD, till what extent the PWD road is there. Because if it is the PWD, it is not a PWD road, then nothing is there. And if it is a PWD road, then we will consider.
My lord, there is no any dispute till my house. There is a PWD road.
No, till your house it is okay. Beyond that, the construction has
My
happened.
lord, they are coming from the upper side to fill up the land on 5 feet and 6 feet upper, my lord. If suppose that road will come to or connect to this PWD road, ultimately my 5-6 feet land will go into that, my lord, that construction, my lord.
Huh?
That is the problem, man.
But that is not PWD road.
My lord, if suppose they come up from the upper side by filling up that, my lord, land, and suppose whatever land level is there, right now the land level of PWD here, my lord. If they will come down, then that will go to up this side, my lord. Then the construction which I have paid out within the limit of that PWD, that will be destroyed, my lord. There is no need dispute, my lord. PWD road up. That's why, my lord, they are taking the law in their own hand because they are action holder, my lord. That's why they have to be stopped
No, they are constructing where?
from their house and they're coming down, my lord,
Where?
to public road, my lord. That
No,
is the-
has the public roads been reached?
Yes, my lord, they're coming.
No,
photographs of-
no. They are coming to the public road where?
Kindly see, Lordship, kindly see the photograph.
Uh,
Lordship, this is the road which has been constructed by PWD, that some blocks are there.
uh.
Now.
Where is
there-
your house?
Yes,
At
my lord.
Annexure 2, where is your house?
This is the, my lord, the first guy that, one of the scooters there, my lord,
Where?
page 20.
With the scooters?
Yes, my lord. This is
The area where the scooter is, that is
Yes.
your road.
Yes, my lord.
Is that a
Now they are
PWD
coming from
road?
the upper side, Lordship, can you see the upper side? They are coming down. If suppose this level they would maintain, then 5-6 feet will be go
No,
down. by-
PWD road is still where?
till,
Annexure
from,
2.
till my house, and there is another house up to date, my lord.
Which one? Show
Another
me.
house. My house is.
You
near-
show it from your picture.
Yes, my
I
lord.
can see from there.
My lord,
No, kindly come this way. Yes.
this is my house.
Ah,
Thereafter another house.
ah.
Up to date, it shows, my lord, the PW road is there.
So PWD road is still this particular portion. This one?
My lord, only this house, my lord. This house, my lord.
Okay.
Yes.
So here till here PWD road.
Yes.
Now thereafter what has happened?
Thereafter, my lord, the on top, my lord, kindly see that 2 or 3 houses are there.
Now
On
there
top.
is some bricks.
My lord, bricks up to that PW road is there, and on top, lordship, kindly see that 2 or 3 houses are there here.
Ah,
They are now coming down, my lord,
ah.
to maintain their suitability of the road, my lord. Therefore, if suppose this construction is continuously going on, and lordship, kindly see that already they have made some blockades. 2 or 3 blockades are there, my lord.
Yes, that
Yes,
is what
they
I'm
cannot,
saying.
my lord, do this kind of thing at their own instance, my lord. If suppose they come
No,
down,
but that is some, these people have jointly done it, all these people.
my lord, jointly they cannot do, because, my lord, this is a public road, my lord.
So if this is not a public road,
Well,
that
even up
forms,
to-
we are concerned with all these bricks which are there.
Exactly, my lord.
So these bricks is not a
My lord,
public
I
road.
don't have any, if suppose this position would be maintained by the private respondent, I'm nothing to say, whatever they want to construct, lordship, they can do it. I do not have any objection. But the position is that what they're constructing, they're coming down from the from upper stream to downstream, and out of which, my lord, 5 or 6 feet will go, and drainage will also already will damage, my lord.
Right?
What I want, lordship, let them take a field verification, submit a report before lordship.
No status quo.
My lord, 4
Nothing,
and 5,
no
they'll-
business of
otherwise they will
status.
carry out
No,
construction, my lord.
sorry. This court till now is not convinced why you should not go to the civil court.
My lord, civil court, my lord, kindly see that our.
You want take these photographs because till here, if their construction, initially I was understanding as to whether the construction is on the public road.
My lord,
If it is if it is a PW road, then obviously they will have a say.
my lord.
But as regards the upper portion, if it is of some public road amongst
Absolutely.
themselves and all, if the other people comes out there is some problem, it's a different thing. We are concerned.
My lord,
But
can-
this is
my
not
lord,
nothing
kindly
to
see,
do.
so far my road is concerned, there is no dispute about the public. I have made my statement in the writ petition. Now, my lord, if suppose the present existing position be maintained by the authority, I have nothing to say. That's why we have approached for the authority, and authority are sitting silent, my lord. They are not acting upon my representation, my lord. Now, whatever construction they are carrying out, now they are totally getting a, my lord, license from the other side, because that whatever. you are saying-
Okay. No status. Issue notice, making it return. When can you get your verification done as to what would it affect the public road or not, the PWD road? You can get it done by 1st of September. Okay. Issue notice making it returnable by 5th of September. I will give you till 8th of September. Mr. B. Chaudhary appears on behalf of the respondent numbers. Mr. Counsel, how are you maintaining the repetition without the state of Assam?
My lord, Guwahati Municipal Corporation. is
Understood.
not good.
Guwahati Municipal Corporation has no business out there. That is not his land.
My lord, that
Guwahati Metropolitan has no business out there.
metropolitan,
What
my lord,
is,
because there is a town planning, my lord, because that
whatever may be, without the state of Assam, how can you make this party?
But
How can you have a department only? We can have a department. It's a different thing. But without the state of Assam, is it possible?
But thing is that so far, my lord, the GMC and GMD is concerned. They are the
So we
opposite.
remove we don't ask him. We don't issue notice to PWD because the state of Assam is not a party.
We'll make it correct, my lord.
Where?
Monday, my lord.
Where?
Monday we'll make it correct in that
Without the state of Assam, how can you maintain this writ petition? You want something against the GMC and GMD, I'll ask them. Matter is over.
My lord,
But
there also-
without the PWD, you have no
My lord,
business.
My lord, no doubt, my lord, the state, Assam is also required to make a party respond number 3, no doubt, my lord. The thing is that, my lord, we'll make it correct, my lord, by on Monday. Yeah, but my lord, at least that inspection part that may be kindly continued. My lord.
But how can I issue direction in this writ
My lord,
petition?
1 and 2 are also consequent, my lord, they are also responsible, my lord, because GMC and GMD are also, my lord, within that area, my lord, GMC, this area also covered under GMC, my lord.
Is that the GMC road?
My notice,
No, I'm asking, is it the GMC road?
train is there, my lord, train is there.
Whether it is the GMC road?
No, it has been constructed
So,
with PWD.
we are only, you are only concerned with that road.
My lord.
What does GMDA have to do?
GMD, my lord, they have to see that suppose this, whatever roads are there, it has been suppose illegally constructed by anyone else, my lord, they can issue notice, my lord, to them. And that's we are alleging that 4 and 5 are carrying out construction. They are answerable before the authority, my lord. That's why we have approached before the authority. They are sitting silent, my lord.
No. Issue notice making it returnable by 8th of September. Mr. S. Bora appears on behalf of the respondent number 1 and 2. Mr. B. Chaudhary appears for respondent number 3. As the respondent numbers 1, 2, and 3 are duly represented, extra copies of the writ petition be served upon them by Monday, by today, during the course of the day. As regards the respondent number 4 and 5, steps be taken by way of registered as well as youth. The petitioner is further directed to serve the said respondent numbers 4 and 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. This court had also put a pointed query upon the learned counsel for the petitioner as to whether the writ petition would be maintainable without the state of Assam being made a party to the instant writ petition. More so when the relief has been sought for from one of the departments of the state of Assam. The learned counsel for the petitioner submits that he would take appropriate steps by filing appropriate application. Well, as the appropriate steps by filing application seeking implement of the state of Assam. The case of the petitioner in brief is that there is a PWD road till to the house of the petitioner. However, on the upper reaches of the said road, which admittedly is not a PWD road, there has been certain constructions being carried out by the respondent number 4 and 5, which would affect the PWD road and thereby could affect the petitioner, whose ingress and egress is out of the said public, is through that PWD road. It is the further case of the petitioner that representations have been submitted to the respondent numbers 1, 2, and 3, but however, no actions have been taken. This court, although this court, upon hearing the parties, the petitioner, is of the opinion that the interest of justice would be met if a report is being sought for from the respondent number 3, that is the PWD department, as to whether the as to whether the construction allegedly constructed by the respondent number 4 and 5 would affect the PWD road. The said report be placed before this court on the next date. In the meantime, the respondent number 3 shall be at liberty to take appropriate action is deemed fit in the action if the construction so constructed allegedly made by the respondent number 4 and 5 would have impact on the PWD road.
Status quo.
But
No.
enough.
Number 27.
Yes.
Lordship, I have gone through the record, Lordship. The very foundation of this writ petition was based on the Honorable Court's order, Lordship. The Lordship has rightly dismissed, has been based on
Where is the eviction notice?
the eviction notice. Your Lordship will find at page number 21, Your Lordship. 20 and 21. 20 and 21, Your Lordship. Annexure 2 and 3. The father of the petitioner, Your Lordship, Parasuram.
Area of land 40 bighas.
Yes.
My goodness. Who is appearing for revenue? No revenue council.
Your Lordship, if Your Lordship peruses the prayer, Lordship, we have not prayed for any setting aside of the eviction notice. We have not prayed for any interim order, stay order, Lordship. We have simply prayed for disposal of the appeal. Lordship, however, we were granted on the last occasion. Lordship, we were not in possession since 2009. Since issuance of this eviction notice, Lordship, we are not enjoying the interim order so granted the last occasion, Your Lordship.
Lahok. How many petitioners?
Lordship, petitioner, 8 petitioners, Lordship.
8 petitioners have joined together in filing the instant writ petition, thereby seeking a direction up to the Deputy Commissioner Tinsukia to dispose of the appeal dated 31/8/2009 filed by the father of the petitioner in pursuant to the order passed by this court dated 27/3/2009, passed in WPC number 1280/2009, as well as the fresh appeal dated 22/11/2011 filed by the petitioner, and for a further direction that the respondent authorities, more particularly the respondent number 2, to dispose of the said appeal by passing a reasoned order, and to refrain from giving effect to the eviction notice dated 3/2/2009. The facts above shows that the petitioners herein allegedly shows that the petitioners are in occupation of government lands. The petitioners herein, the facts as would appear from the writ petition, would show that the petitioners herein are in occupation of government lands. The petitioners have also admitted that the lands are government lands by making payment of Tawzi Moza. Bracket there. A penalty fee for occupation of government lands, bracket closed. The subdivisional officer, C. Margarita, had issued a notice to the petitioners, various notices to the petitioners. To vacate the lands, comma, tea cultivations, comma, mustard cultivations, etc., within 15 days from the date of receipt of the said notice. It was also informed that if the petitioners do not vacate the area, they shall be evicted from the land by law. The petitioner challenged those notices before this court. In WPC number 1280/2009, this court, by an order dated 27/3/2009, had observed that the petitioners were issued eviction notice as per the provisions of the Assam Land and Revenue Regulation 1886. And as such, the writ petitions were dismissed. However, taking into account the submission so made by the learned counsel for the petitioners therein, then before the court in the said writ petition, liberty was granted to approach, however, taking into account the submissions so made by the learned counsel for the petitioners in the said writ petition, that the petitioners have an appellate remedy to approach the Deputy Commissioner Tinsukia. This court granted the liberty to approach the appellate authority. It further reveals from the records that the petitioners thereupon approached the Deputy Commissioner Tinsukia the predecessor in interest of the petitioners as well as the petitioners subsequently approached the Deputy Commissioner Tinsukia, challenging those eviction notices. However, the said appeals were kept pending. And as such, the present writ petition has been filed. Mr. Counsel, why have you filed this writ petition? Why are you filing this?
The appeal may be, as it was not.
After that, have they taken any steps?
No, Lord.
Then,
a reminder letter was also issued by.
then why are you taking these steps?
Present petition.
You should be sitting quiet, isn't it?
No, Lordship, we were not in possession, Lordship. We were already thrown out since 2009, Lordship.
Then
We are not in possession, Lordship. And there's this construction as it is evident from the Honorable Court Order 2009, no construction was in, Lordship. In the present situation, many encroachers have encroached encroach the said land.
No, Mr. Counsel. The land of
Other
the Iman in
process
this
is now
connection have
taking
produced,
over
he
the
has
land.
also produced the scheme of Iman, thus schemes have been. What is your appeal?
Lordship,
What appeal is this? We have received the aforesaid letter from the Iman, we cannot take the possession of our patta land and we have been evicted from our patta land by the subdivisional land for the same we have been purchased. I preferred appeals before the Deputy Commissioner in Sukia. A perusal of the said appeals shows that the petitioner's claim, petitioner as well as the predecessor in interest of the petition, some of the petitioners, as well as the petitioner's claim that they have been thrown out from the patta land. However, and thus said aspect have not yet been adjudicated, for which the instant writ petition has been filed. This court, upon hearing the learned counsels for the parties, and this court had heard the learned counsel for the petitioners, and put a specific query upon the petitioner as to what is the basis of the appeal so filed, inasmuch as the petitioner's claim, inasmuch as a perusal of the appeal so filed shows that the predecessor in interest of the petitioners as well as the petitioners claim that they have been evicted from their patta lands. This court had therefore put a specific query upon the learned counsel for the petitioner as to whether they have any patta over any, have been issued any patta over the lands in question. The learned counsel for the petitioner could not show any such document. When the matter was taken up yesterday, thereby giving the opportunity, a further opportunity to the petitioner to produce it today. The learned counsel for the petitioner has, however, drawn the attention to Annexure 1, a perusal of which would show that these are documents
those is, I think,
showing payment of land revenue, payment of Tozi Moza, which is a penalty paid for occupation of government lands. Under such circumstances, this court is of the opinion the issuance of notice under such circumstances, the question of deciding the said appeal under such circumstances, as the subject matter of the said appeals is non-existent, inasmuch as the petition, the predecessor in interest of the petitioners, of interest of the petitioners as well as the petitioner, have no right over the government lands. Nothing survives to be decided in the said appeals. Accordingly, therefore, the question of directing the Deputy Commissioner to decide those appeals as has been sought for directions to be issued to the Deputy Commissioner for deciding those appeals have been sought for. Cannot be issued. Furthermore, from a perusal of those appeals, it is seen that the petitioners have already been evicted. And as such, not to give effect, and as such, the direction sought for not to give effect to the notice dated 3/2/2009 also does not arise. Accordingly, this court finds no merit in the petition for which stands dismissed. This court, however, observed that the petitioner shall be at liberty to approach the Deputy Commissioner seeking compensation for the loss of their, for the loss sustained by them from being evicted, loss sustained by them as regards the structure standing over the government lands from where they have been evicted.
Page 30, we have prayed for it.
Huh?
Page 30, last page 30, we have prayed. the complex part
So you go there.
of that.
And number 9.
Mr. Biswas, why don't you go to the Police Accountability Commission?
My lord, unfortunately, the man who has handcuffed me has expired.
No, does the Police Accountability Commission has no power to grant you compensation?
My lord, I have not checked up that, my lord, but my lord, for compensation, because that would probably,
No, you want a fault. You want a self-vindication to that effect that they, whatever they did, it was wrong.
Yes.
In fact, the recent judgment of the Supreme Court that day I was looking into of Justice Ravindra Bhatt also says as to when a person should be handcuffed.
my lord, the mother judgment in this regard is Prem Kumar Shukla,
Mm.
full bench judgment. In fact, there was a mandate in the Punjab police manual
Mm.
where handcuffed, perimetry with the Assam police manual, where a person who is charged of a non-bailable offense can be handcuffed
Mm.
during the transit period from this. Now, that Prem Kumar Shukla, my lord, that case was registered on the basis of a communication from the jail. A habeas corpus petition was registered. The Delhi High Court initially said that no, since there is a mandate in the manual, they can do it. Then this matter went to the Supreme Court.
Mm.
Then, my lord, the Supreme Court says this is violative of 21, and the Supreme Court has elaborately explained as to when handcuff has to be resorted to and when a person should not be handcuffed. The general rule is that, my lord, a person should not be handcuffed unless his attendance could not be secured with handcuffing. Now, here is a case, my lord, where he is a resident of Pan Bazaar and, my lord, he is a practicing advocate of the city, my lord.
Mm.
Now, and there is evidence on record which says that he has voluntarily surrendered before the police station.
Mm.
My lord, I'm not going into the merit of the allegation as such, my lord.
We are only concerned with the handcuff, no?
Yes, yes.
Nothing more than that.
Nothing, not even an inch more than that.
Because other aspects have been already taken care of by the
Taken care of.
criminal trial.
Absolutely, my lord. Therefore, my lord, I'm not even referring to the merit of the case. I'm being acquitted, my lord. Now, the question is, my lord, whether this action of the state is in consonance with the mandate of the law as propounded by the Honorable Apex Court in 2 judgments which I could lay my hands on, and 1 judgment of the Bombay High Court and 1 judgment of our High Court. Now, even in our High Court judgment, where my lord, late Nilodatta sir versus the state of Assam, in that judgment also, my lord, the petitioner was handcuffed from Guwahati and was taken to Misa jail.
And in that transit period, he was he was chained. Then, my lord, the then Advocate General, they relied on the Assam Police Manual. And I have checked, my lord, the provision still remains the same. They have checked. But this Honorable Court, relying on the Prem Kumar Shukla judgment and other judgment, had said, no, this is inhuman. And therefore, my lord, a 10,000 rupees compensation was granted. Apart from the factum of handcuffing, there were other ancillary issues in Sir Lilo Datta's case, my lord. There were other issues also, ill treatment in the jail and everything. I'm not going into that, but handcuffing was one of the factum for which compensation was granted. Similarly, my lord, in Prem Kumar Shukla, that's, my lord, that's the first judgment I could lay my hands on. That judgment, it's a full bench judgment, my lord, 3-judge bench judgment. I take your lordship to my compilation at page number 4.
Just 1 minute.
Absolutely.
That's 1 minute.
Yes.
Which judgment you are referring to?
My lord, if your lordship kindly takes up this small compilation which I have made.
Yes, I will be.
My lord,
Handcuffing is 214.
214, and there is one more I have given, my lord. This is 273
Okay.
of the Assam Police Manual. My lord, I'll come to this Assam Police Manual after going, my lord.
No, I'll wait. Yes.
If your lordship kindly comes to page number 4 of my compilation.
This Prem
Shankar Shukla.
Hmm.
Now, my lord, here is a case which I was referring to, my lord. My lord, page number 7. This judgment starts with a very interesting quote from a German philosopher, my lord, which says, when they arrested here is a symbolic of a wrong done by a state. When they arrested my neighbor, I did not protest. When they arrested the man and woman in the opposite house, I did not protest. And when they finally came for me, there was nobody left to protest. Now, my lord, page number 8, that was the order passed by the Delhi High Court. In plain language, my lord is there, my lord, in plain language. In plain language, it means that ordinarily Indian under trials shall be routinely handcuffed during transit between jail and court, and the better class prisoner shall be so confined only if reasonably apprehended to be violent or rescued. Now, my lord, this was a very strange term, better class prisoner in the Punjab Police Manual. However, the court have even said that this should go, my lord. Now, I take your lordship to the relevant part, my lord. My lord will kindly come to page number. Yes, page number 16, my lord. Para 30. Even in cases where in extreme circumstances handcuffs has to be put on the prisoners, the escorting authority must record contemporaneously the reasons for doing so. Otherwise, under Article 21, the procedure will be unfair and bad in law, nor will mere recording the reasons do, as that can be mechanically processed, mindlessly made. The escorting officer, whenever he handcuffs a prisoner produced in court, must show the reasons so recorded to the presiding judge and get his approval. Otherwise, there is no control over possible arbitrariness in applying handcuffs and fetters. The meanings
kindly
of the...
come to para 22.
My lord, para 22. Yes, my lord. Handcuffing is prima facie inhuman and therefore unreasonable, is over harsh, and at the first flush arbitrary.
Hmm.
Absent fair procedure and objective monitoring, to inflict irons is to resort to zoological strategies repugnant to Article 21.
Hmm.
Thus, we must critically examine the jurisdiction offered by the state for this mode of restraint. Surely, the competing claims of securing the prisoner from fleeing and protecting his personality from barbarity have to be harmonized. To prevent the escape of an under trial is in public interest, reasonably just, and cannot by itself be castigated. But to bind a man hand and foot, fetter his limbs with loops of steel, shuffle him along in the street, and stand him for hours in the court is to torture him, defile his dignity, vulgarize society, and foul the soul of our constitutional culture. Where then do we draw the human line, and how far do the rules are in print and praxis? Now, yes, my lord, I was referring to para 30 and 31. Even in cases where in extreme circumstance, page number 16 of my compilation, even in cases where in extreme circumstances handcuffs has to be put on the prisoner, the escorting authority must record contemporaneously the reasons for doing so. Otherwise, under Article 21, the procedure will be unfair and bad in law. Nor will mere recording the reasons do, as that can be mechanically processed, mindlessly made. The escorting officer, whenever he handcuffs a prisoner produced in court, must show the reasons to so recorded to the presiding judge and get his approval. Otherwise, there is no control over possible arbitrariness in applying handcuffs and fetters. The means of the police establishment must make good their security recipes by getting judicial.
There is something in Ernest Kumar.
Arnesh Kumar is, my lord, with regard to probably whatever I understand, it's with regard to notice section 41.
No.
Handcuffing.
There's also something like that. Because that is what I read recently. In fact, it has been recently circulated by the Supreme Court, directed to be circulated. I know that judgment came on 14/8.
I'll have to check up, my lord. Because, my lord, what is happening, my lord, if your lordship, my lord, in this PI court, my lord, the under trials, they're being chained, my lord, and while taking their attendance, they are made to kneel down while counting their head.
No,
Now, my
in
lord,
fact, Mr. Viswas, I do agree to you on this aspect because I have seen it with my own eyes that 6-7% together being brought out there before the CJM court, tied out in one rope,
absolutely.
and just they are all bound by one rope. And although they have not been, one is handcuffed and the last one is handcuffed, and all the others are just tied with the rope. So that is, I've seen it.
And especially, my lord, while producing them before the different courts, my lord, while their attendance is taken, my lord, that scenario is also not very healthy, my lord, because they're made to sit in the floor while counting the heads, my lord.
Okay, no, I've understood your point. Yes, Mr. Sharma. No, agree with for what? You want a compensation? How much? You agree to that? Very well. 5 lakhs? How much? 5 lakhs you have asked?
Any amount that your lordship.
5 lakhs, yes. No, this is, no, you see, what, no, whatever you say out there, this has been done by an official, whoever is done, we are not bothered. But the fact that he has done under the authority of the police. Now, this police have done it. Tomorrow, that person may be alive or he might have died. That is immaterial. But it is state who have done this. So for that, any indignation which has happened to the petitioner, it is required to be compensated. How much is a different thing? He's not. But the thing is, something needs to be done. So I've asked him to get the judgment. I've not got it till now. But you submit on what do you...
Judgment lordship, most probably lordship, in the case of the handcuffing, they have to take permission from me. I have done before. And That Niloy case got if that is also report most probably in
Yes.
1992.
That is there.
Then I have granted Lordship. Yes, but it's a wrong term, Lord. I should not argue Lordship on.
This is another 302 case where Supreme Court has come down heavily on handcuffing, my lord. If man was charged under 302,
Nowadays, most probably I have seen some 80% Lordship, they are bringing the prisoners by putting their hands like this. Sometimes I have seen that. Most probably because of all this department.
my lord will appreciate this fact, my lord. A man is handcuffed and subsequently acquitted. So the charges has not been proved against him.
Handcuffing is earlier Lordship. Thereafter trial,
That
but
is-
that is not the, that one should not be handcuffed. That is the
That is-
message by, from the honorable court as well as the high.
No, it is not that they cannot be handcuffed,
Yes.
they can, but depending on the seriousness of the offense.
But in that
But
case
here,
also,
what was the allegation against the petitioner?
regarding
By
this person,
allegation.
Huh?
that he has prevented the officer on duty.
Huh?
That was the allegation.
Too much.
Huh.
That is not the bad. Even Lordship is Onil Batra's case, most probably the search Sobras was also there Lordship, in that case. Even in that case also Lordship the violation of the Article 20.
That judgment, which is there at serial number 4 of my compilation, Supreme Court, my lord, that was a murder case, my lord. The
Which
court-
one? I'm coming. Let me try these people could, yeah, got it.
Income tax officer versus Anil Batra.
Okay, done. Decide. I don't have a CV, so let me make a CV. There's something to write up.
And if your lordship, my lord, if your lordship decides that this handcuffing should not be done, my lord, at least, my lord, that's my prayer, my lord, that if your lordship sends a communication at least to the police.
Oh, yes. Don't worry.
I am just
No, that will be done. Don't
I'm
worry.
so deeply obliged, my lord. That's the main purpose.
Having completed judgment results.
I'm deeply obliged.
Otherwise, my lord, the hearing was almost completed, my lord.
I think better you settle it up, Mr. Ahmed. If this court passes an order, then the consequences will be later on. In every case, there will be a similar claims. I fix it on 12th of September. 12th of September. In the meantime, try to settle it out because otherwise this court is going to pass an order. Pass an order that you are liable to pay the interest on that. Once that comes in, there will be various litigations where you are doing similar things. So I think you try to settle it up. They are your regular vendor. They could purchases your coal from there. Huh? So if he's a regular customer, try to settle it out. If you don't, you know the consequence. It will lead to a lot of other litigation later. Doing what? I only gave you an opportunity to settle it. List the matter again on 12th of September 2023 for further consideration.
I'm clear.
I don't know, 10 to 12.
Lordship.
First point two is useless. Come to the second point.
On the last
If there is a delay in communicating,
Lordship.
what is the effect?
Yes, Lordship, in the rules, there is no such limitation that they have to issue the demand notice within so and so period. All the limitations are for the SSEs and there are no limitations for the department. Being so, Lordship, Supreme Court has propounded some restraint. For that, I would like to furnish these judgments to the Lord. Lordship, the first judgment that I refer to is 1994 State of AP versus Ramakishtiya. On the back side, Lordship, third line, as stated above, the order of the Deputy Commissioner is said to have been made on.
Where? In this judgment, 1994,
Lordship.
Supreme Court.
Lordship.
Yes.
State of AP versus M. Ramakishtiya. Back page, Lordship, third line, as stated above, the order of Deputy Commissioner is said to have been made on January 6, 1973, but it was served upon the SSE on November 21, 1973. That is precisely 10.5 months later. There is no explanation from the Deputy Commissioner why it was so delayed. If there had been a proper explanation, it would have been a different matter. But in the absence of any explanation whatsoever, we must presume that the order was not made on the date it purports to have been made. It could have been made after the expiry of prescribed 4 years period. The civil appeal of the state is accordingly dismissed, Lordship. Subsequently, Lordship, it is 1979, Assistant Transport Commissioner, Lucknow. Paragraph 2 on the back page, Lordship, line number 4. We may give one more reason in our judgment, and that is this. It is plain that mere writing an order in the file kept in the office of the taxation officer is no order in the eye of law, in the sense of affecting the rights of the parties for whom the order is meant. The order must be communicated either directly or constructively in the sense of making it known, which may make it possible for the authority to say that the party affected must be deemed to have known the order. In a given case, the date of putting the order of communication under certain circumstances may be taken to be the date of the communication of the order or the date of the order, but ordinarily and generally speaking, the order would be effective against the person affected by it only when it comes to the knowledge either directly or constructively, otherwise not. One more, Lordship, finally. 1989, Government of India versus Citadel Fine Pharma. Paragraph 6, Lordship, page 4.
Yes.
The line number 7, Lordship, after Article 14 of the Constitution, in the absence of any period of limitation, it is settled that every authority is to exercise the power within a reasonable period. What would be reasonable period would depend upon the facts of each case. Whenever a question regarding the inordinate delay in issuance of notice of demand is raised, it would be open to the SSE to contend that it is bad on the ground of delay, and it will be for the relevant officer to consider the question whether in the facts and circumstances of the case, notice or demand for recovery was made within reasonable period. No hard and fast rules can be laid down in this regard, as the determination of the question will depend upon the facts of the case, Lordship. Lordship, there is a delay of 1.5 years.
No, the question is, let us see your order.
Yes, Lordship, it is at page 31, Lordship.
page 31. Yes.
Serial number 4 would.
This was, order was of 21/12/2017.
Lordship, and the period, relevant period is 2013-14 as per serial number 4 above.
This is audit assessment has to be completed within what period?
Within 5 years from the end of the assessment year, Lordship.
Within 5 years from the end of the assessment year would be, that means,
19, 31st of March 19, Lordship.
and when you were issued the notice?
I was issued the notice, Lordship, it is page 28. The issue says 2nd of July 2019, Lordship. Above, right side,
2nd of July 2019.
Lordship.
And the period ended on 31st of March 2019.
Lordship.
And the other two cases?
Lordship, the item number 12 will be on similar ground on limitation. But item number 11 will be regarding the best judgment notice not issued, Lordship.
That is not there.
Lordship
is
will
no.
have a look at the law again, Lordship.
No, that is not there. But this is a point.
Lordship.
Okay, now coming to this audit assessment, this is a certified copy of the assessment award.
Lordship. In the item number 10, which is in the hands of your Lordship, Lordship will peruse page number 32.
32, yes.
In serial number 15 below,
Hmm.
penalty has been imposed under section 34, 5,000.
Hmm.
No penalty can be imposed. 34 says that the opportunity of hearing has to be given.
Hmm?
Section 34 itself says that before levy of penalty, reasonable opportunity of being heard has to be given. In this order, the penalty has also been levied upon me, Lordship, apart from the plea of limitation. The other effect of this order is, Lordship, input tax credit on the purchases, local purchases made by me has been denied.
No. That thing I'm not going to touch. Not under 226. I'm not going to touch that aspect.
Only principles of natural justice, Lordship. I was not directed to produce my purchase invoices. Notices ought to have been given to me, Lordship.
There is this notice which have been issued to you.
Lordship, it is only regarding initiation. As soon as a dealer gets an initiation notice.
You are hereby informed that a certificate against you of so for amount of tax and demand is being issued. This is what?
That is not the notice, Lordship.
Huh?
That is not the notice, Lordship.
The notice
will
on the
be page
27.
27, Lordship. It is the initiation, Lordship. They have started the proceedings.
Now, whereas the return filed by you for the year 2012-13 to 2014-15 have been selected for audit assessment
Lordship.
under section 1 of section 36.
Lordship.
And it has become necessary to make an assessment under subsection 5 of that section.
Lordship.
This was done when?
This was done, Lordship, 11th of May 2017.
Okay. You are to appear, you are hereby required to appear in person. Now, thereupon you appeared.
Lordship, I appeared.
Okay.
I take a plea in my writ petition that I have appeared and I have.
But you were not communicated about the assessment order.
I was not communicated after passing of the assessment order.
Okay.
But Lordship, during when the proceedings were being taken place, my plea is I have appeared and I have cooperated with them. But their case is that in the order they say I have failed to comply. As soon as I fail to comply, Lordship, section 37 comes into play. 37(1)(c).
Oh, I got that.
There are two types of assessment that can be completed, Lordship, whether audit or otherwise. Either it is based on the books of accounts or it is based on best judgment.
Muta gitu. Oh, yes, section
37(1)(c), Lordship.
has failed to comply with the terms of the notice under subsection 1 of section or subsection 3 of the
36. Lordship, C has been
notice,
expressly
of
mentioned in the
dealer
impugned
the
order.
original photo and the prescribed manner so as to give him a reasonable opportunity to access him to the best of his judgment.
Again, Lordship, D has also to some extent been mentioned in the impugned order.
All right. Now, what is the period for best judgment?
The period will be the same, Lordship. Section 39 prescribes 5 years.
And this assessment order has to be communicated to you. How do you know? How do you say so?
Because they have to recover it from me, Lordship.
No, it's okay. No assessment under the foregoing provision shall be made after the expiry of 5 years from the end of the year to which the assessment relates. Provided that in case of offences under this act for which proceedings have been initiated, limitations shall not apply.
Proviso is not applicable, Lordship.
So they have to do it within 5 years.
So, Lordship, my humble submission is 2 kinds of assessment, Lordship, either based on books of accounts or best judgment. As soon as it is best judgment, Lordship, there is a compulsory mandate of law to issue notice to me, which has not been issued to me in all the 3 cases.
Where is it necessary?
Lordship,
So you say that as per if the conditions A to D is fulfilled,
Lordship, any of them.
then the prescribed authority after issuance of notice to the dealer
Lordship,
and in the prescribed manner so as to give him a reasonable option of heard, assess him to the best judge.
Lordship, my submission is as soon as an audit assessment proceeding is initiated, a dealer so petty, so high whatsoever, he might elect not to attend, Lordship. But whenever the assessing authority reaches to a conclusion that he proposes to assess me in such and such manner, he issues a notice to me expressing his intention to do so, providing me an opportunity to show cause why he should not do so.
But what do you say about 36(5)(b)?
Lordship, 36(5) mentions the powers.
36(5)(b).
Lordship, the prescribed authority derives its powers from section 36(5)(b), what he can do when he initiates an audit assessment proceedings. But even under 36, if he proceeds to assess me, Lordship, he has to give me a notice expressing his intention, what he wants to do.
Now, does it say about the notice?
Lordship, the proviso says so.
Where?
In the 36(5) itself, Lordship.
Yes.
And Lordship, this is what the law says. Even in the absence of law, the rules of natural justice would say that
Rely on any evidence collected by him.
Lordship,
So are you saying that any other evidence have been taken into consideration?
Lordship, I have failed to comply as per his order.
Let's see the assessment order.
Lordship.
Page 31.
Page 31, Lordship. The case records of Messr so and so taken for detailed scrutiny assessments for period 13-14 under section 36 of the VAT Act as per order number so and so. As such, issued notice for production of required books of account under reference number so and so. The date fixed for productions required books of accounts. Sri Vishal Kumar Jha, proprietor, along with so and so of the firm, appeared before me on 31st of May 17 and asked to produce required books of accounts in relation with business transaction, that is purchase and sales invoices. But the dealer fails to comply with the terms of the notices. It is his case, Lordship, that I have failed to comply. Hence, assessment proceedings taken upon the basis of information available in my possession and records available. On verification of record, it appears that the dealer deals in CC fabrics, PVC cloth, polythene sheet. The dealer purchases goods.
Just 1 minute. Just 1 minute. Now the notice which has been issued here says yes. Notice has been issued here.
27.
Please take note that in the event of your you are to appear in person, produce evidence or have been produced in support of your produced or caused to be produced of so and so document. To maintain and furnish declaration and certificates you are required to furnish under Assam value error the rules made therein under relating to the enforcement. Please take note that in the event of your failure without sufficient cause to You will render yourself liable to the best of my judgment without burden.
If I have completed several audit assessments before the department personally. In those cases, what happens, Lordship, as soon as I appear after giving the initial notice, when I appear, some of them will give the prescribed format. You furnish the details of all your sales, you furnish the details of all your purchases, sales return, purchase return, whatsoever. After submission of the same, if they get anything, even then, Lordship, before creating any demand or assessment, they have to issue a show cause notice to me, giving me an opportunity why they should not do so. There are some authorities who would not give a prescribed format, they will take my ledger account from my books of accounts in support of sales and purchases reported by me. But dealer can also choose not to attend after getting the initiation notice because he is so small, he cannot afford a consultant, Lordship. In that case, only upon getting a show cause proposing demand, he will come into picture, Lordship. That is how it is happening, Lordship, regularly.
No, they are saying that it has become necessary to make an assessment under subsection 5 of section of that of section 36 in
Okay.
respect to that.
There are several factors on the basis of which they select a case for audit assessment. It might be that the purchases they see that it is too much beyond the prescribed limit for selecting for audit assessment. There may be a case that the sales, they have their information as per the check gates, but the sales is underreported. They might select it for audit assessment. But along with that, there is also a provision that they might select it randomly. So my case is in random selection. There is a rule which enumerates all the reasons on which the audit assessment can be selected.
Yes.
It is Rule 22 of the Assam Value Added Tax Rules, Lordship. There are several categories which has been mentioned, out of which one is random. Lordship will peruse 2219 cases selected at random.
Yes.
And there are several other prescribed limits if anything.
So your cases came in under the random.
I assume so, Lordship. There is no written record to that effect. Because I am a very petty dealer, Lordship.
And what type of notice is this?
Which
I
one?
mean, it doesn't say anything what is to be produced, nothing.
This is initiation. It is an intimation to me that you have been selected for audit. You come and we will keep directing, you keep producing.
And if you don't appear,
If I
then
don't
they
appear,
will go to 37.
yes, they will go to 37. Lordship. Best judgment.
So if they go to 37,
Yes, Lordship.
now is there any notice? Because it says after notice of after issuance of notice to the dealer in the prescribed form,
Lordship.
meaning thereby there will be a notice for this.
There is a Lordship.
Let us see.
There is a notice. The Rule 23 also says so that a notice has to be given for best judgment. And then there is a notice called Form 21, Lordship. The Assam Value Added Tax Rules 2005. The
Yes.
notice has been appended, Lordship. Form 21.
And what is this notice under section? This one, best judgment is so and so. Yes.
Yes, Lord.
So this is a notice under 20. This
37.
one.
37, Lordship.
No, page 655. You have that book
I
or
have
no?
a
No.
commentary, Lord.
Anyways, that notice that is Form 20 is the notice which was given to you.
That is the initiation, Lordship.
Okay. And then Form 21
Has not been given. to me,
has not been issued. to you.
Lordship.
Whereas you being the registered dealer have failed to furnish the annual return for the period from so and so and thereby rendered yourself liable to be assessed for best judgment.
All those ABC in
Or
37,
you
Lordship.
have been knowingly furnished incomplete or yeah. Or you have failed to supply so and so. Or you have failed to maintain. So you are hereby requested to appear in person. So this is another opportunity.
Another notice which has to be given before completion of assessment.
Okay. And the second is the period of limitation.
Lordship. Only in 10 and 12. Item number 10 and 12.
And what about 11?
11 is only this notice.
No notice 37.
Lord.
Yes. Tell me. Mr. Chaudhary, you tell me two things. One is regarding the notice on the Form 21. Form 20 is regarding informing certain officer thing that you are going to go for a
Audit assessment.
audit assessment. Asking him to produce the necessary documents. He fails. He does not. Let's assume he has not, as you have stated. But to go for the best judgment, there is a Form 21. And it categorically is mentioned in Section 37, Rule 23. That you have to issue notice. That is one. Form 20, which is for Rule 36, Section 36, also says that they will otherwise do their judgment to the best of their. But the problem arises that he did not submit, but you have taken into account certain other materials, as could be seen from the assessment order. Then can you do so in view of the proviso to Section 36(5)? This is the second one. The third is, as per Section 39, there's a limitation of 5 years. You have not informed him, or is it required to inform or not, the assessment order? If it is required to be informed, and you have not informed him, you have issued the notice pursuant to the period of limitation being over, then it would be taken that you may have done it at a later stage. And as such, it goes beyond the period of limitation. So that is for item number 10 and 12. But as regards item number 11, this is the point. These are the 2 points. One is, you issue a notice under Section 36 in Form 20, only for the purpose of appearing and to produce certain materials. He does not. You take into consideration some other materials without a notice which is mandated under Section 36(5). Now, Section 37 says that if a person does not produce in consequence to the notice under Section 36, then you can very well go for under 37 for making the best judgment. And if you go for a best judgment, you are required to issue a notice under Section 30, under in Form 20, in Rule 23, read with Form 21. How do you take care of these three situations?
appears that the assessing officer has not assessed on the basis of some other matter
He says only, na? Come see the assessment order.
on the basis of the annual return. That is reflected from the.
You see what is written, but the dealer failed to comply with the terms of the notice. Hence, assessments is taken up on the basis of information available in my possession and records available. On verification report, it appears that the dealer deals with so-and-so, so-and-so. The dealers purchase goods locally as well as from outside. Verification also repeats the GP ratio reflects as so-and-so. And also go with the scrutiny of so-and-so, where interest levied under so-and-so and penalty of amount. The trading amount ranges to so-and-so, so-and-so. On scrutiny of the different monthly returns, it has been observed that the dealer nor reflected any purchases under form so-and-so. As such, I have reasons to believe that the dealer concealed his total income, and as such, he intentionally left blank of Part A of monthly returns. So under such circumstances, I reject his self-assessment and proceed for assessment as follows. So therefore, he has done it. You yourself say that from the materials available with you.
That material is the annual that the monthly return and the annual return that has from that basis, they reflect from the record of it. On that basis, it will open for the best. Because he has not collected any other, because not known to the paying and closing on 31st/5/2017, the petitioner appeared, and thereafter he was allowed to complete certain record. Thereafter, not even a single he appeared, and accordingly, lawsuit assessment was made, and yes, the record reveals that one notice was directed to be prepared. Thereafter, when it was prepared and ordered, that doesn't reveal from the record. And
So you say that there was no other materials taken.
No.
So therefore, the compliance with 36(5), the proviso to 36(5) is not necessary. But you are doing it to the best of your judgment.
yes, that's what
Then if it is done to the best of the judgment, are you therefore not required under form 21? See the form 21.
yes, then that is not from the that,
Section 36 only gives one situation where best judgment assessment can be completed when the dealer is not found at his registered place of business. If he is absconding. In that case, without any notice, they can pass assessment orders. Other than that, it does not give any provision to the officer to pass best judgment assessment under 36.
No,
36(3)
36(5).
36(3) lordship. It only gives 36(3) only allows best judgment, no other provision, lordship. If he has given a false address while registering. Court will again note the difference of what the officer can do. 36(5)(b) lordship. It gives the power to the officer to assess the amount of tax due from the dealer. He is only calculating the tax, he is not assessing the turnover. Now, lordship will peruse section 37, what powers are given. After A, B, C, D, lordship, the prescribed authority shall, after issue of notice to the dealer in the prescribed so as to give him a reasonable, assess him to the best of his judgment. There is a difference between both the language employed,
No.
lordship.
If you see, if any dealer so and so,
Okay.
prescribed after issuance of notice to the dealer in the prescribed in the remark, so as to give him an opportunity to assess him to the best of his judgment.
In 37, he is assessing me completely regarding turnover whatsoever. In 36.5, he is only assessing the tax due from me. There is a difference between both the language employed, Lordship. He has to give a notice expressing what he wants to do, Lordship.
Hmm.
Otherwise, I have not been given an opportunity to meet the case. He's taking a plea.
So
that-
here, as per 36.5,
Lordship,
either he shall confirm the assessment
Lordship,
or set aside the self-assessment
Lordship.
under section and assess the amount of tax due from the dealer.
Yes, Lordship, there can be several things that sales return was done after 6 months. It is not admissible as per rules. So he will only calculate the tax due from. But he can assess the turnover only in 37.
Hmm?
Turnover has been enhanced in item number 11 and 12, Lordship.
Now here,
In 10, it has not been enhanced, Lordship.
32, page 32.
Page 32, turnover has not been enhanced, Lordship. ITC credit has not been given. But he has not given notice that you produce purchase invoices in support of ITC. Input tax credit. If he was to disallow it, he should have given a notice, you produce the purchase invoices.
Any purchase.
He's telling that in the monthly return, the purchases field was left blank. But he's not talking about the annual return. As soon as the annual return is filed, the monthly return, unless it is contradictory totally, loses significance. I have enclosed the annual return of turnover, which specifies the purchases. And the credit has been claimed in the annual return of turnover, and when my returns were scrutinized, a penalty of 2,000 was levied upon me because the monthly returns were not mentioning that figure. Now again, they will penalize me for the same, and they will disallow without issuing notices.
But 10 has a problem with the limitation. Huh?
10 and 12 lot.
Here the period would end on
31/3/19 lordship.
so he can only assess the tax due,
Lordship.
but not
36.
impose the penalty.
Yes, Lord. In 37, there is separate provisions. If he assesses tax, he is giving notice. In B, again, if he levies penalty, he gives notice. 37B, 1B. Both are mentioned separately. (37)(2), sorry, Lord.
Hmm?
37(2), it is for penalty. 37(1) is for tax.
So here you have exercised 37 by imposing penalty.
Lord. He has mentioned 34. 34 again mentions about notice.
No. Here he has mentioned here.
Lordship.
You know, on page 32,
Lordship.
he imposes penalty as well as tax.
Yes, Lord.
So he exercised 37.
37.
When so it can't be because here 35, 36.5 only says about tax.
Lordship.
So when he has exercised 30,
doing
both
everything.
penalty and so, it will be an exercise under 37.
Lordship.
And 37 can't be done without the notice.
It is mandate.
Any judgments on the any other thing?
Yes, Lordship, the judgments will be on penalty that no penalty can be imposed.
That I know. Okay. Then,
Thereafter, Lordship, about notices, there are judgments of the Supreme Court to the effect that even if the law does not say that the notice has to be issued, it still has to be given.
no, here notice is there.
But thereafter, Lordship, since the Lordship has noted a difference between the language employed in section 36 and section 37, therefore, a Supreme Court judgment to the effect that while interpreting a taxing statute, the words have to be given plain effect and no interpretation is required if it is not called for, Lordship.
No, therefore, in this item, that is 42523, the exercise was made under 37
Lordship,
because they have imposed penalty.
Lordship.
If he had only assessed the tax, then it could have been related to 36(5). But he has not done so. He has assessed the tax as well as penalty.
Lordship,
And as such, it has been done under 36,
Lordship, 37.
which requires notice.
Notice, Lordship.
So this is 10.
This is 10, Lordship.
What about 11?
Now, 11, Lordship, will again note page 31, Lordship, which is a part of the impugned order.
Here also, there no penalty.
Here is, it is no penalty, Lordship, but Lordship will note the table Roman number 2, serial 2.
Hmm.
The sales, it is mentioning two figures, plus 2 lakh, 24 lakhs plus 40 lakhs.
Where? Item number?
Lordship, the paragraph which is running last 3 lines, last 4 lines. So under such circumstances, I reject his self-assessment and proceed for assessment with my best judgment. He is himself mentioning that he is doing a best judgment by enhancing so-and-so turnover in so-and-so schedule.
Page 31.
Page 31, Lordship. The paragraph, last 4 lines. The paragraph in
So
between.
under such circumstances, I reject the self-assessment
Lordship.
and proceed for assessment with my best judgment by enhancing
Lordship.
so-and-so of schedule 2 and 40 lakhs determining turnover as follows. So thereby he increases.
He increases, so he can only calculate the tax. If he assesses me and my turnover, again 37 comes into play.
So you mean to say that if on the basis of the turnover so reached, he assesses the tax,
Yes, sir.
then it will come under 36(5).
If on my turnover,
But when he increases the turnover,
Lordship.
then it will come under 37.
But Lordship, this I am agreeing only to agree to concur with your Lordship's opinion. Even if he completes assessment under 36(5), he still has to give me a notice, Lordship.
Why?
Lordship, he has to tell me what is the case being prepared against me. How do I defend myself? If he does not inform what is the case against me that he proposes to do, how do I produce the relevant papers? The first notice is only a generalized notice. You produce everything under the sun.
Mr. Chaudhary, these particular notices were issued as random. These are randomly done. No, these are randomly. This, you see, there are many audit assessments which are done on random basis. Sometimes audit objections are received, they are doing it.
Yes.
But this is a random thing done. So if random is done, you are, when you issue notice, isn't it required in view of the various laws laid down by the Supreme Court? You have to say what is the deficiency. Now, if you say the deficiency out there means from he has not produced. We have asked him, he has not produced. But why have you asked him? Nothing. Have you asked him anything? You only say that you have been chosen out for audit assessment of so and so, be prepare, appear, produce all your returns, so and so, so and so. Understood. So that is done. So if that is being done, You find out here, you have asked them to produce these documents. He does not. Then it will come under 37. You can do it under 37. Because 36 does not say that if non-production, you can do it. Does it say? 36(5) says the prescribed authority shall, after considering all evidence produced in course of the proceedings or collected by him, either do all these things. But 37 clearly says that if he has failed to produce in terms with the notice under so and so, then the prescribed shall issue notice under 21. So you asked him to produce, he failed. Then you are to say under 21, Form 21, that this is this which is there. Then again ask him to do, give him an opportunity. See Form 21. Isn't it? Again, you give him the same opportunity. If he fails to produce.
The authority went by that Form 20. The last.
Understood, you can do it.
Yes.
If you don't come up anything, then if you don't represent or don't do anything, I will pass my order. Very well. But then you will be exercising 36(5). But by way 36(5), can you do so by taking into account any other amount? And if you are taking any other amount, you have any other materials?
Yes.
If you have any other materials, then again you are hit by the proviso.
37 will come in. But here from the record and the fiscal data, it seems that he made the assessment only on the basis of the.
Understood?
final.
No, that is what I'm saying. In item number 10, you have exercised not, you could have only access the text, assess the text. But what you have done, not only assess the text, but also the penalty. Thereby, you have actually exercised 37. That is okay. But item number 11, what you have done, you have increased the turnover.
That's okay.
If you can't increase, and if the turnover is increased, therefore you have not imposed a penalty. But can you increase the turnover without 37? And the main problem which arises is you have not served him. Is there any provision of serving the notice, the assessment order? How does a person know about the assessment order?
What the provision says that after completion of assessment, he will issue a demand notice and he will serve upon me. When, in what period, it does not mean.
So if the period is made after that,
Yes.
there might be a thing that it may be done later on also, because there the limitation question comes in. Otherwise, there is no prejudice. But if the period, within that period, the period of limitation expires, no demand notice has been issued and he has no information, it may be done only 2 days before then. That is the problem.
Here the record reveals that the demand notice was prepared in the meeting. But when it was prepared, that
No, unless he doesn't know, he can't help it. No?
that is.
Because that record can also,
Be made out.
that is the reason why the Supreme Court says no? That record can be manipulated. Hearing complete, judgment result.
Lordship, specific aspects of 11 and 12, I have mentioned in a sheet for the convenience of.
Okay, very good. I will set aside, giving you the liberty to do as per law. Now, whether it is permissible or not, that is your lookout. But I am not going to give you the liberty for reassessment. Thereby, I will be enhancing the limitation.
Lordship, scrutiny has already been completed. Payments have also been made against that scrutiny.
No, that what you want to do it. That is your lookout. I am not on that. But these orders needs to be set aside. The consequences thereupon, you know what to do. You are more versed. I'm a pension judge. Yes.
Lordship, highly obliged, Lordship.
Hearing complete judgment. Yes, there is a motion. Somebody's
Unlisted,
GB Chaudhary holding.
item number 3.
Yes, what is it?
Well, I executed a transportation contract in 2015 to 2017 with HCI. Thereafter, my lord, all my SD monies were given. I have given no demand certificate in 2017 itself. By the impugn order, which has been passed, my lord, in June 2023, my lord, the FCI, without giving me any hearing, my lord, has passed an order asking me to immediately pay 2 crore something, because they say that the distance what was mentioned in NIT, my lord, that was a wrong distance.
Hmm.
In fact, the distance was lesser, my lord.
Then
So that's why, my lord, I'm before your lordship, my lord.
this demand notice,
Demand notice.
Annexure 10,
Annexure 10, my lord, page 30.
G20.
No notice was given to me, my lord, prior to this. After 6 years, they passed this order, my lord.
Huh? So they will be adjusted against your SD and BG. You have other contracts.
Other contracts, my lord.
They will be doing it.
That they are empowered to do it, my lord.
Yes.
There is a mechanism in the journal of the FCI that any dispute arises, they can refer that can be referred to here demonstrated steps. So they can put their grievances before the judge and a time frame may be given for exposing that dispute. That is clause 20B of the tender document. That of course not annexed. Learned to any of the aware of that. They say that no opportunity has been given. You will get the ample of.
So you won't do anything till you decide.
Yes, my
Yes, yes.
What is that?
GRC, my lord.
GRC.
Grievance Redressal Committee.
Huh?
Clause 20B of tender document.
Where is it?
No, NIT and that.
That has not been connected.
How do I know?
GRC is there, my lord. There is an admitted fact. The lordship refers to GRC. All the matter dispute goes to GRC. But here, my lord, I have taken a ground that, my lord, since it was without notice and since it was a concluded contract, my lord, GRC has no power. But if they are submitting that they'll consider and meantime no action being taken, then, my lord, that can be, my lord, acceded to, my lord.
The petitioner herein have challenged the demand notice dated 4/8/2023, whereby the petitioner has been directed to deposit an amount of rupees 2.11 crores to the Food Corporation of India within 15 days from the date of issue of the said notice. It has been also observed in the said demand notice that if the petitioner fails to do so, the said amount shall be adjusted against the available security deposit, bracket SD and BG, oblique, bracket close, BG, bracket close, oblique, running bills from other contracts with the FCI. The legal counsel for the petitioner submits that the petitioner has contracts with the FCI presently. You have?
Yes, 6, 7 contracts.
And as such, the said amount which have been illegally imposed upon the petitioner in respect to a concluded contract, which has, in respect of which a certificate has also been issued. Is absolutely illegal and unauthorized. Mr. B.K. Jain, appearing on behalf of the FCI, however, submits that there is a grievance redressal committee of the FCI, wherein Mr. B. Chakraborty further submits that the demand notice dated 4/8/2023 is also in violation to the principles of natural justice, inasmuch as there is not a single, inasmuch as the said demand notice have been issued without even given any opportunity to the petitioner to explain. Mr. B.K. Jain, the learned counsel appearing on behalf of B.K. Singh, the learned counsel appearing on behalf of the FCI, submits that there is a grievance redressal committee of the FCI, wherein all these issues so raised by the petitioner can be very well adjudicated. He further submits that as the petitioner's allegation is that no opportunity of hearing has been granted prior to the issuance of the demand notice, the petitioner can raise all these the said grievance of the petitioner can also be raised before the said grievance redressal committee. Mr. B. Chakraborty, the learned counsel for the petitioner, submits that the petitioner has no objection in approaching the grievance redressal committee. However, during the pendency of the said proceedings before the grievance redressal committee, the demand notice dated 4/8/2023 should not be acted upon. He further submitted he would submit the necessary representation before the grievance redressal committee by
Anytime, only.
tomorrow.
2 weeks. No problem. 2 weeks, my lord, very old contract, 2 weeks may be given, some papers may be necessary.
By 30th of August. 30. By 30th of August 2023. Taking into account the above submissions, this court disposes of the instant writ petition, thereby giving the liberty to the petitioner to approach the grievance redressal committee of the FCI within 30/8/2023. The grievance redressal committee of the FCI thereupon shall give the petitioner a reasonable opportunity of hearing and pass appropriate orders as deemed proper. Within a period of 60 days thereupon. This court further directs that till the grievance redressal committee does not pass this court further directs that till the disposal of the representations shall be submitted by the petitioner by the grievance redressal committee. The demand notice dated 4/8/2023 shall remain suspended. Above petition stand disposed.
All right.
Number 13.
Yes.
Lordship, actually, I applied for a the retail outlet of my lord in terms of the advertisement issued by.
Oh, yes, I remember.
Yeah.
Yes, Mr. Chaudhary. That land belongs to the husband. Then what is there? Consider a case also, put her in grieve one. If you've not done. Because after all, the land, the moment the husband dies, first of all, I would have understood that she has put it in her application as her land. She categorically mentions that it is my husband's land. But the fact that the husband died is also mentioned, and therefore the land also devolves upon her. But does it say that because the land otherwise by operation of law has already devolved upon the petitioner? After the death.
Yeah.
Upon the death, it's automatically devolves upon the petitioner because the succession does not stop. The succession immediately happens upon the death.
Whether it devolves upon petitioner alone or others might not don't have any independent at that point of time, might so that if I and it's a very part of the part of the that not followed by now by they are in certain process your lordship. I understand, my lord. But then, my lord, perhaps I was also what is the order path? Order path is that your application will not be considered as
Group 3 will come later on. Group 1, Group 2, and Group 3.
Yes.
Now, Group 3, if a person is selected out there in Group 1, the opportunity of going to Group 2 also does not arise. Then?
Now your lordship can see the guidelines. The eligibility criteria, my lord, the lordship find that all 4.
Yes.
There the lordship my lord, the requirement of land. Roman 5.
Yes.
Or land not offered by one either by your ownership or long-term deed. So my lord, the ownership is the my lord requirement. Then my lord not offered the land. Then my lord for A, for A, the land should be available as a bigger and the or could have become 9 years. Next week, my lord, for the applicant of the group 1 have to establish ownership of land offered for the petition as of the date. So my lord, as of the date of application, it was my lord, the land was standing in the name of this. Then my lord, was the various situations of ownership for defining form of are as answered. Your lordship company.
The number E, the land owned by the family member will also be considered as belonging to the applicant, subject to producing the consent letter in the form of an affidavit from the concerned family member. For the purpose of the family members would comprise of self, spouse.
But the spouse cannot give a note that it's going to be there. That your lordship company. The land owned by the family member will also be considered as able to be applicant for subject to the consent letter in the form of an affidavit of concerned family member. So that was not given. Had that been there, as part of the I have better confidence. Well, I expect point of the from a different perspective. If the conflict comes to 7 to 3 family, they with the same mother or not, if they interrupt the application of the consent letter on sample for of it for an escape from power better of home. So at that point of time, we do not know for the legal aid. Had that been there?
No, only one thing, Mr. Ghosh,
Lordship.
tell me one thing. Did you submit any affidavit?
My lord, we have submitted affidavit from a lawyer, my lord, what is required, my lord. If your lordship look into
On the
the
none of
age,
my family members.
the eligibility of the applicant,
No, tell me one thing. You are, what's your name? Yes. You are from the Mohammedan community.
more the common under.
Now, Mohammedan community, if it is so,
Yes,
uh,
under section 41 of the act, it is tenancy in my lord common, that's it,
Huh?
tenant in common. That my
so the
interest-
moment the death
Yes,
happens,
yes,
then what is what does your husband have? Means husband's how does it devolve?
then my, it is development in me and a distinguished, as a distinguished share. It is not a my lord ownership in common.
Then
It is not an ownership in common.
now how many people are there? Means the husband is there, husband's mother is there,
Not mother is there, my lord.
husband's father is there.
Father is not there, my lord. But I am
Then who is there?
Then son and daughter is there.
Son is there. So
son
son's share will be more than that. Then how do you take care of that?
my lord, here, my lord, as per my lord, the after
Son
the
and
divorce-
daughter is what is the age?
My lord.
What is the age of the son and daughter?
So that-
Because if it is I think you will be belonging to the Sunni Hanafi law.
Yeah, my lord.
And if it is the Hanafi law, obviously the son will get the more. Yours will be only 1/8.
My lord, that instruction right now I do not have my. Right now I do not have, but my lord.
I fixed the matter only for today's disposal so that they can proceed.
Yes, my-
No, only one thing, why I'm saying, if whether the son and daughter, what is the age of the son and daughter? Because if the son and daughter's age is minor and she is the guardian, then again it devolves, minor can't give an affidavit.
Lordship.
So if that document is produced, you see, whatever may be, how many persons are there in group 1? There will be some more. Not only him, many more. It's a draw of lots.
Yes.
If they get a lucky out there, it is well and fine. This is not that being in group 1, she will be the only one. There will be a draw of lots and only then only one person will get. We'll have it on next Tuesday. I'll dispose it off. You get to know all these things.
Lordship,
How many sons and daughters are there?
what is their age?
Huh?
What are their age?
Absolutely. And sons and daughters, and thereafter what is, what documents and what is their age, so that we can take on it. And whether there is a mother, whether there is a father.
Father, mother is not there so far. But so far age.
Because the mother also gets one share.
Yes, yes.
Brother won't get it, mother will also get a share.
Yes.
Find out. We'll take it up on Tuesday.
No.
It's the matter again on Tuesday for final disposal.
I can, for affidavit, I can produce them.
Understood. Where? Before the grievance redressal forum.
I leave it to my lord. I leave it to my lord.
You see, this needs to be ironed out. I will ask you to produce, then there might be complications.
Okay.
I want, okay, contest out there in group one if you are otherwise entitled.
Otherwise,
If the daughters and sons and daughters, yes, it may devolve. But the fact that they are not in a position to give an affidavit, because an affidavit by a minor would not be
yes,
considered to be
no,
an affidavit. Because that affidavit a minor can't give it.
But if they are major, the matter will be maybe different.
Absolutely. And what is the age of yours?
My age, my lord, is around. But right now I can say 56 now. So my sons and
There
daughters
the
may be
problem
major.
arises. If they are major, then you can't. Then in that case, without that affidavit, you can't. This is the matter again on Tuesday, on which date Mr. Ghosh, the learned counsel for the petitioner, shall apprise this court as to the legal, as regards the legal representatives of late, his name? What is the name of the legal representative of late Samiul Hussain. The interim order passed earlier shall continue till then. Great.
14.
I passed the interim over in his absence.
Lordship.
Lordship, I have the instructions to withdraw this matter.
Okay, very good.
But because
Miss-
Lordship, there is a arbitration clause already there in the contract. So we would like to go for a
It's a termination.
termination, yeah, Lordship. So basically at that point of time, Lordship, it was filed for illegal termination as well as some stay orders for invocation of BZs and performance bank guarantees and advance bank guarantees. But now like I mean, it seems that BZs have already expired. BZs have already expired. Contract is over in 2000.
And there was a stay.
There is no stay. There was no stay.
There was no stay.
There was no stay. There was no. So there is a clause of arbitration. So we would like to go to arbitration. Here. The page 50, your lordship will find.
The learned counsel appearing for the petitioner. Mr. A. Colita submits that he has been instructed to withdraw the instant writ petition, taking into account that there would be certain questions of fact, that the dispute involved in the instant writ petition would entail adjudication of certain facts which this court may not be, which may not be, which this court may not like to adjudicate. He submitted that as per the tender conditions clause.
Clause, 1 second, lordship. Clause 50, clause 8, clause 8 of the tender, clause 8. It's at page 50, your lordship. Page 50, clause 8. Settlement of disputes.
Page
50, lordship.
As per clause 8 of the general conditions of contract, 8.2 of the general conditions of contract, there is an arbitration clause. And the petitioner would therefore approach, take appropriate steps in that regard. Taking into account the above submission, the instant writ petition stands dismissed on withdrawal. The dismissal of the writ petition on withdrawal shall not affect or prejudice the petitioner. In the eventuality, the petitioner initiates any proceedings under clause 8.2 of the general conditions of the contract.
Obliging.
Give your name.
15,
Your Lordship. As per the last order, the government side sought some time to obtain
I have
instruction.
not received any instruction as regard the passing of the award dated so and so. Till date from respondent number 2 and thus paid for you. Yes?
And for our file.
No. Award. Award has been passed? When? And what is the matter about? Set aside an impugn notice issued and proceedings. Forthwith release the compensation amount to the petitioner, being the compensation for the acquisition of land owned by the petitioner, measuring so and so. So you are a private person.
Yes.
You are also entitled to the 79 lakhs.
I'm interested person for it.
Interested means
I have the interest in the property which have been acquired by the airport authority. But if there is a dispute in terms of apportionment of compensation,
so. How can this court decide?
because the scenery is that Lordship,
This is done under what provision, Mr.
As per sections,
section 30.
section
2013 Act? 2013 Act, if it is done, then you have to move under 64.
Your
Then-
Lordship, it's under section 6(1) of the Assam Land Acquisition and Requisition.
This was done under 64.
64.
Then you have to do under 12B. As regards apportionment, isn't it? Under what provision the acquisition was done? Show me the award. And how is this matter listed today?
It has come by order, but we have not mentioned it.
Huh? Oh, this is an award passed under what provision? Let us see name of the project, acquisition on the basis of zonal value, date of demand, name of the person as stated in the so-and-so. Rule 33, created 23 and 30 of the Land Acquisition Act. Amount to be allowed. Damages under section 20, 30. 100% is given. Polysium 30, 100% given, 1.5 every month. This is land is what? This amount. Dag number 803, patta number 803, dag number 1884, 48. So there, how many petitioners are here?
3.
What are the
We are
names?
acquiring this land since 1977, Your Lordship.
Madam, what are the name of the petitioners?
They are the petitioner number 1 and 3 are the legal heirs of the district.
Name.
Sarat Kumar Das is the petitioner number 2.
And?
Debajani Das is the petitioner number 1 and Srimati Das is the petitioner number 3.
Debojani Das is where?
The wife of Deben Das.
Okay.
Late
So Deben Das
Das.
name is there.
Yes, sir.
And the third one?
Tazuram Das. Tazuram Das and Umakanta Das.
Umakanto Das is where? Umakanto Das is there. And
Sarat Kumar Das.
Sarat Kumar Das, they are there. So they are all Tozoram Das sons.
Yes.
Okay. Now their names are there in the Pattadar. Then what is the problem?
They are objecting. Respondent number 5 is objecting, Your Lordship, for the disbursement of the compensation.
And why are you before this court?
because the authorities, respondent authorities are not disbursing the compensation amount that we are.
Who are you? What's your name?
Respondent number
Obindas.
number
Huh? No, your name is not here. Huh? Obindas.
Sobindas.
Huh?
THABIN or SABIN, your lordship.
Obindas. Obindas, son of Horiram Das.
Hariram.
Obindas is there. Yes. Obindas. Obindas is not there.
I think Cooperative is not the recorded particular. His mother was the recorded particular, Redamper, and his petition application already has made control of it. Fundamental plan has expired by the authority. So, lot of scenario is that there are land in this dark 8 bigger freedom, out of which 5 bigger equivalent. There are 15 parted and hold the land unified under the same system. It is undivided property. So whose portion of land, how determined?
So?
Total land is not expired.
No, so?
My dispute is that it is a dispute in terms of the portion of the property.
Very well. Understood. Then?
So also, as land acquired 5 acres out of 8 bigger 3 acres. So it is the petitioner declared this portion of land 2 bigger 10 acres to go out of 5 acres. How it is not? Because it's undivided property. It is unified under the same schedule of land. Petitioner alone.
No, both of you. I'm not understanding both of you one question. Why you have not approached the authority when the award was passed? Award was passed when? Award statement dated? Award was passed when? Is this filing a repetition out here? Huh, Mr. Talukdar? Huh? Where? Approval. Approval. This is done under LA Act, is done under award in respect of LA for acquisition of land for construction of new terminal of so and so. LA case. Now, one thing is very not clear. What is the problem? This is done under what provision? Compensation is under this, but this is under 64A. Both of you, whoever wants approach the authority for apportionment under 12, and they will then thereupon will make a reference. I passed the detailed order that day. You got a copy? I gave a copy to you. Diana, I have asked to give the copy to her for the purpose of intimating the chief secretary, no, the commissioner and secretary, revenue department, directing the deputy commissioners and the collectors out there to forthwith make the reference, because any delay out there will affect them. So the acquisition has been made under the 2064 Act. For the purpose of, and the payment of compensation has been made under the 2013. So they are to, this is a case for apportionment, they have to go under 12. Oh.
I'll take
What is
proper
that?
instructions, your lordship.
What?
I'll take proper instructions.
For what? You want money?
Yes.
He wants, who wants money? Fight it out. There. What is this court going to do? Can this court divide that, okay, you give him here and so, no. And in the meantime, you deposit, you have not released, you deposit in the court. You have to deposit under before the authority as per this act. So you deposit. Chalo, we'll pass the order today. Disposed.
Obliged.
Give your names, whoever is appearing.
Sixteen to 21.
Yes, what is this matter about? Oh, you have encashed? Those matters, did it come before this call?
This is another, that was another matter.
Ah. This is encashment in respect to where contract you have changed.
There is a deviation. There is a deviation in the payment conditions, my lord. Thereafter, we back off, my lord, and then
This will be covered by Justice Manish Chaudhary's judgment,
yes, my lord.
which has been
Yes,
approved by
my lord.
the
Yes.
division
Yes.
bench.
Yes, my lord. Similarly situated.
16, 17, 18 and 21 may perhaps be covered. But 19 and 20 are definitely covered.
19 and 20 goes by that Gujarat
19
matter.
and 20, your lordship, why it is not covered? Because 17 and 21. So there is objection to payment term. Your objection to in terms of the lender as well. But that issue has perhaps been dealt with some less by the 16, 17, 18 and 21 may perhaps be covered. But in 19 and 20, instead of 19 and 20, there is an unequivocal acceptance by the petition. Once an acceptance is rendered, the concluded contract comes into it. So once a concluded contract is there, then they will have to face the consequences of not doing it. So 19 and 20 are okay.
So what to do? Today no time.
In case, my lord, my 19 and 20 may be taken up on some other day, and other 4 may be disposed of as he has admitted. At least this 4 matter is covered, and 19 and 20 we will argue, my
But
lord.
then also this court has to write. No?
Yes, my
I will only apply the law laid down, but the facts have to be mentioned.
Facts is different.
Then how do I do it? We'll have it on some other day.
Second week of September, my lord, if it is convenient to your lordship. September. Any date from 11 to 15.
Let's have it on 14th of September.
My lord.
14th of September. List the matters on 14th of September at the top of the list.
Obliged.
Number 22. Please, my lords. My lords, I'm grateful for my lords giving us this virtual hearing. May I call attention to my lord's previous order? Matter is now listed for final disposal. It's a matter which arises under the service tax law, my lords. My lord's previous order is of 28/7/23, my lords.
Yes.
And the issue of alternate remedy had come up and my lords dealt with it. And then para 6, my lords has listed it for final disposal. My lord, I'm ready to go on. I heard my lord's comment in terms of the time that we are at end of the day. So should I begin? I'm happy to, or my lord would fix another date.
You see, what I could see from your petition.
Yes, ma'am.
Is you are saying that this is covered by the judgment of the Supreme Court, wherein it says as regards the surplus earned by the brand owner cannot be made chargeable to service tax at the hands of the manufacturer.
My lords are right. My preliminary submission is the board has clarified the position that the brand owner's surplus cannot be taxed by way of a clarification in the year 2009. That particular clarification is squarely on the issue that brand owner's surplus is in the nature of an income by way of profit and therefore cannot be charged to indirect tax, that is service tax. It should be charged to income tax. That particular circular is a clear answer to what they are trying to do as a department in this case. We urged that circular before them. They have recorded it in the impugned order, but they haven't dealt with it in the context of the order. My lords are aware that as regards departmental clarifications, the law is clear and in two parts. One, officers of the department are obliged and duty bound to follow those circulars. And if an order is passed contrary to a circular, it is ab initio bad in law. That's what the Supreme Court says in the Indian Oil Corporation. Another argument we have is the one that my lords made, that this issue also via the route of the tribunal went up to the Honorable Supreme Court. The relevant tribunal judgment is in the case of BDA distilleries, where in detail they effectively went into this issue. When it went to the Honorable Supreme Court, the Supreme Court effectively says that it's dismissed because they didn't see any merit in it. So we have a tribunal judgment which in that manner has been affirmed by the Supreme Court. The Supreme Court order is not at length, but it is still a situation where the Supreme Court has endorsed what the tribunal has said. So primarily I rely on the circular issued by the board. I also rely on the tribunal judgment which went up to Supreme Court and where Supreme Court dismissed the department's appeal.
Now, the department's case is that it comes under the business auxiliary services.
Yes, Manoj. The question that it will come under business auxiliary service. As my lords are aware, in the context of service tax, there are two situations we'll have to deal with. Firstly, is there a service which is rendered? And the period we are dealing with, my lords, is from the October of 2015 up to the March of 2017. As my lords are aware, in this period, there was a regime which was distinct from the earlier regime, which was pre-17-2012. Pre-17-2012, we had specifications of what is the taxable entry. Business auxiliary service was one of those. Post-17-2012, we moved to what we call the negative list regime. 1st of July 2012. We moved to a regime which is called the negative list regime, under which the situation was generically all services would be taxable, but if you were in a negative list, then you would not be taxable. So while the department says we would come under business auxiliary, one of the issues which would come up is, in fact, at the relevant point in time, there were no specific taxable services like business auxiliary which were operative. So that apart, my lords, we would still have to determine, of course, whether we are a service which is taxable. Once we determine whether there is service which is taxable, the second issue we have to determine is the brand owner surplus actually taxable in the hand of the bottler who does the job work? Or is the brand owner surplus not in fact consideration for what is done by the bottler? Because the bottler receives bottling fees and he receives certain reimbursements. The bottling fees have already paid tax. The reimbursements have also paid tax. The issue is whether the brand owner's surplus is taxable. There, as I said, we are covered by the board circular to say that the brand owner's surplus can't be added to the value of the service of the bottler. And the brand owner's surplus, being a pure profit of the brand owner, cannot effectively be charged to service tax as the indirect tax, since it is already being subjected to income tax. So, my lords, this is the conspicuous of the matters. Whenever my lord would like to hear it.
Yes, Mr. Yeah, Mr. Shah?
Yes, yes, my lord.
Okay, when you like to do it?
Would my lords please give me the 21st of September if it suits my lord?
Too long a date. 21st of September.
14.
Okay, 21st of September. Then.
Yeah, my lords, there was an order of interim protection.
Yes,
from
yes,
the
we'll extend delay.
Yeah. I'm grateful to my Lord for giving me this opportunity.
Heard the learned counsel for the petitioner, Mr.
Rohan Samet.
Arsa, have been heard on the matter. On account of paucity of time, the hearing could not be completed. List the matter again on 21st of September. Interim order passed earlier shall continue till then.
Grateful to my Lord.
Number 25 and 26.
Yes, you got it. How much you have received out of 17 lakhs? Why there are two petitions? One is 5 lakhs and one is 13 lakhs. And what is your thing? When
Lordship already 1 lakh 3,000 standard process for payment. The rest will be paid. Lordship and give us 2 months time.
you'll pay this. The total is 3,19,148.
Yet to be received, my lord.
You are going to pay that
My lord.
within 3 months from today.
Lordship 3 lakhs. No, Lordship.
No, you are saying from your own document.
No, that Lordship, but if Lordship look at it.
No, what is this document? This is with reference to this, I have the honor to submit the report regarding payments to have been made till date to so and so. As per the so and so amount, bill payment of Bizonda 15 lakhs, paid value 12 lakhs, remaining is 2,30,000. Final bill value of council 579, paid value is 488. Total these two is 3,19,000. Payment in process, including agency charge at 11.5% is 1,03,000. The balance, the payment is in process, which is divided between the two contractors of so and so respectively. So remaining will be 2,15,000. So as of now, you have not paid this. Have you paid this? As per now, how much he has got?
He has got 18,900.
No. Bizondas have got 9 lakhs. Part payment after deduction of agency charges and other taxes, 9 lakhs.
9 lakh.
Council has got so and so.
3,26,000.
With another demand draft of 1,03,000 to the respondent number 7 as full and final payment, but the said amount. As per the above, so and so has already paid full executed value of the contract amount of rupees demand, except agency charge as demanded by the respondent number 7. And despite that, the agency charge has already deducted the agency charge from the petitioner at the time of part payment. Now the petition, both the petitioner collectively yet to receive this. So both of you agree that both of you are entitled to only 3,148,000, of which how much is whose?
My lord.
How much is whose? Out of this this is, you are entitled to, one petitioner is entitled to 2,15,968 and the other petitioner is entitled to 1,03,183.
29, my lord. Okay.
Of?
Item number 25, my lord.
Yes.
Total executed value, my lord, 18,77,980. and subsequently agency charge.
So you have left that agency charge.
Agency charge deducted from my lord, but Nobode Sangothon, my lord, committee paid the entire our executive value, my lord, 18,77,980. But
Then
that committee has not paid that 2,15,968. In spite of that, my lord, the PW respondent number 7 deducted the said agency charge from us, my lord.
understood, but you see, you are saying that 3,19,000 is payable as per this document.
I can't understand how they get the 2,15,000.
No. There are two amounts. Why this 2,15,000 is total is 3,19,000 for both.
Both.
1,03,000 is in the process pipeline.
Yes.
So that pipeline has not reached the end persons.
That
So
is-
therefore, 2,15,000 plus 1,03,000 comes to this 3,19,000.
Okay, 1,03,000 is under process. Maybe by month time. Allow me 2 or 3 months. Then the rest if it
So therefore, I am not saying anything else. I am saying that both of you, you pay this 3,19,000, of which 2,15,000 to petitioner of this, and the second also to this petitioner of 1,03,000 within 3 months from today.
there
Not-
are 2 petitions.
That is what I'm saying. One will get 2,15,000, the other will be 1,03,000. Total is 3,19,000. There is no quarrel with that.
Yep.
Now, 1,03,000 is in the pipeline, shall also be taken into account while computing 3,19,000. That's it. Isn't it?
My lord.
Okay, Lekha. এটা দি দিম ইটো কৰি দিম। চলো। The petitioner is aggrieved. The petitioner herein has filed the instant writ petition, being aggrieved by the inaction on the part of the respondent number 1 and 2 in not releasing the admitted liability amounting to rupees 13,58,297, and as such have sought for a direction for release of the said amount along with interest at the rate of 18% per annum. It reveals from the records that in the meantime, during the pendency of the instant writ petition, the entire amount the respondent appears from a perusal of the petition that the respondent number 9 had already released the said amount after deducting the service charge. No. Have already released. Okay, have already released the said amount to the respondent number 7, to which the petitioner is entitled to. However, the respondent number 7, in the meantime, have only released an amount of rupees 12,83,648. But an amount of rupees 2,30,831 still remains payable to the petitioner. This court, while taking up the matter yesterday on 16/8/2023, had directed Mr. B. Chaudhary, appearing on behalf of the PWD, to obtain instruction as to when the said amount of rupees 2,30,831 would be released to the petitioner, taking into account that the amount has already been disbursed by the respondent number 9 to the respondent number 7. Today, when the matter has been taken up, the Mr. B. Chaudhary submits that within a period of 3 months from today, the said amount would be released. Taking into account that the respondent number 9 have already released the amount to the PWD authorities, and the PWD authorities are duty bound to release the said amount to the petitioner. This court directs the PWD department, and more particularly the respondent number 7. No.
Executive Engineer, PWD.
The respondent number 7 to release the amount of rupees 2,30,831. No. 2,15,000. 2,30,000. 2,15,968. आज की तारीख by 16th of November 2023, it is made clear that if the said amount, if the respondent number 7 fails to disburse the said amount to the petitioner as directed, interest at the rate of 18% would be leviable on the said amount from the date of the default, and the said amount, said interest, be paid by the PWD department, which shall be recovered from the salary of the respondent number 7. With the above, the petition stands dismissed. Then only things work. Salary is the base.
Let be from the one with what.
No. I have given you from today. No, the default will occur only from that day. After 3 months. 16th. You pay that. Otherwise, interest from the salary of the present incumbent of the respondent number 7. Holding the post of the respondent.
Second one. Second.
Okay, the second petition, you will give it alone. You just give it out there. Clarify what are the requirements. A copy of the order be furnished by the registry to Mr. B. Chaudhary for onward information to the respondent number 7 for needful compliance. The instructions were submitted by Mr. B. Chaudhary during the course of the hearing is kept on record and marked with the letter X. এই দুইটাতে হবে দুবারে X.